Ladies and gentlemen, can I have your kind attention, please? We'll be starting in 5 minutes with our next panel discussion. Ladies and gentlemen, I would request you to please be seated again for our next panel discussion. All right, we're all back from a refreshment break, and I hope you all are having a good time. And now, without any further delay, let's quickly jump into our next panel discussion on the topic Unlocking Opportunities, Exploring the Consequences of Permitting Foreign Lawyers and Law Firms to Practice Foreign Laws in India. To discuss this, I would like to welcome on stage the moderator of this panel discussion, Ms. Shelley Kohli, Chief Legal and Compliance Officer at United Breweries Limited. Let's have a huge round of applause, everyone. Mr. Ravi Rajiv Upadhyay, Senior Director, Head Legal, India Operations, Ameriprise Financial Services, LLC. Please welcome, sir. Ms. Monica Romalina Sijabat, Founder and Managing Partner at MRS Business Professionals Consulting, who's also our Powered By and Cocktail sponsor. Please welcome Ms. Monica. And our fourth panelist, Mr. Balakrishnan Gopalakrishnan, Founder, BJK Law Associate, Advocates and Legal Advisors. A huge round of applause, everyone, for all our panelists. Now I would request the moderator to please commence the panel discussion. Thank you.
Hello everyone, how are you doing? I hope you had a great break. This is a rather heavy topic, and the reason is it's a topic that evokes a lot of different reactions, divergent views, and a lot of debate, right? And rightfully so, the panel has a nice blend of in-house counsels. Okay. Yes. I hope you don't mind. It'll be easier for the audience, I guess, to put the face to the sort of the real person. Yeah. Okay. So as I said, we have a panel which has a nice blend of in-house legal, external law firm, and a foreign attorney as well. So the idea is to really get to you the divergent views and make it a very interesting conversation. But before I go to the questions to the different panelists, I just wanted to put a brief background. And I tried to do a little bit of research to make sure that I set the context for you guys to sort of follow the conversation after. So now, as you all know, the Advocates Act actually prohibits foreigners from practicing law in India. And despite there have been over the years some sort of the activity or the other as far as foreign firms and foreign lawyers is concerned. And therefore, writ petitions had been filed before the Madras High Court and the Bombay High Court in the past. And the Madras High Court case actually culminated into a Supreme Court decision later because it was appealed. And in terms of the broad principles, and that decision was in the case of this A.K. Balaji versus Government of India, I'm just going to reiterate the broad principles that were laid down, and because that is important for us to understand the foundational principles of how this conversation has been evolving. So the Madras High Court basically in the A.K. Balaji case said that foreign lawyers are not restricted from participating as far as negotiations, deals, contract drafting, etc. is concerned. They can actually provide consultancy support. They can participate in international commercial arbitration, and they can operate on what they call, in inverted commas, actually fly in and fly out basis for advising clients on foreign law in India. Yeah. Now, this judgment was actually very much aligned to what the Bombay High Court had also said. And as I said before, this decision then went on in appeal to the Supreme Court, and Supreme Court actually widely endorsed pretty much all of the principles that I just articulated for you. Yeah. Interestingly, also the Supreme Court said that practice of the profession actually is not restricted to litigation. So it is litigious as well as non-litigious practice, which can be construed as practice of the profession, right? And since then on, what has recently happened is that we have the Bar Council of India rules that were promulgated last year in March. And I think that's the reason why you see this topic as a topic of discussion in many of the conferences that are being held. Now, so that's the context. And now, so over to the different panelists that I have here with me. So I will go to Bala first. Bala, to you. So now, as far as I wanted you to comment and throw some light on the effectiveness of the BCI rules that have come, which have allowed foreign lawyers and law firms to register with the Bar Council of India. And as you know, that the pretext of this is that India is looking to establish itself as an international hub for international commercial arbitration. So my question to you is, do you think this is like a forward stance in that direction? And what's your view?
Yeah, I think, can you hear me? Yeah, I'm Gopal Krishnan Balkrishna, and formerly I was the head of law department of Axis Bank, and I was also after that I was heading the asset reconstruction company, that is a RSIL, with the first Indian asset reconstruction company. And now I'm practicing on my own. I've set up a law firm called BGK Law Associates, that is, and before I come into the topic, one topic, Dr. Basin, my good friend, was saying that it should be allowed that, because this is also allowing foreign law firms to practice in India, that in-house general counsel should be allowed to represent their companies. So I was one of the people who had always appearing before, when I was in Axis Bank, before the income tax tribunal, because I was looking after the income tax matters also. And therefore, I used to appear and represent and plead the case for the Axis Bank. And therefore, I got a membership in the income tax advocates tribunal in Ahmedabad, because our headquarters was in Ahmedabad, and therefore, it was there. So there is nothing wrong in it, and therefore you can represent your own company, because you know the facts much better than sending it to somebody else. Back to the question. The question is that, let me ask a simple question to all of you here. Who is afraid of these foreign firms coming to India? I think only a certain big law firms who have established here are afraid of these foreign law firms coming to India. Because if you look at the Indian context, there are two types of lawyers. If you look at the Mofussil towns, or, in certain districts across India, I'm not blaming any particular state. They are completely different. And, they're coming from law colleges, which, I don't know what kind of law colleges are there, because the law schools have mushroomed like, small, we would say small mom and pop stores, and everybody is given, because it is given on a communal basis, and if you're given on a society basis, and everybody is there. Because I can say that because I'm in the board of studies of two big law schools in India, one in Bangalore and one in Bhubaneswar. And what happens is they are completely unaware whether foreign law firms come or not. It is not going to affect their thing, because they are into litigation, and their work sphere is limited. People in Bombay, especially Mumbai, where I'm coming from, Delhi, and then in Bangalore and in Hyderabad, they are afraid, because so that is where the foreign investments have come, and foreigners come every day. So today, as the panelist, as the moderator has said, Balaji said that fly in and fly out. I think I don't agree with that, because they can come fly in and fly out means see, it's not a one-night stand where somebody can come and then go back. That they have to have a responsibility here. When they are coming here, they have to have some responsibility in advising the clients and in what they are doing. They just can't do anything and go back, because now Supreme Court is also considering the matter whether advocates can be brought in under the Consumer Protection Act, because that's a case which is still pending, because the Chief Justice asked a question whether, why can't it be? So if it comes, that's going to be a dangerous thing, because we'll have to defend our own cases. A lot of our own cases will have to be there. that's about that apart. Now today BCI has come out with certain rules, which rules I feel is very good in the sense, they have to register here. And if I'm correct, they have to have a partner with a local Indian lawyer. And, the local Indian lawyer are there, so it brings a lot of opportunities for the young, bright minds, lawyers in India, because law students coming from good law schools or otherwise, who are bright young students, they have a lot of opportunities because they have a right to do that. If you look at the other in foreign law firms also, they have an India desk and they recruit people from here, from the law schools, and keep them there. They're not enrolled or they're not registered with that country. But what they do is, they shuttle between India and that country of their posting, and they know they have to bring work to them. For example, any international work is there, that has to be there. So as far as the Indian context is concerned, one is that they should be registered with with the BCI. That's a good thing. Registration is necessary, and they should have a partner, a sponsorship. Like if you go to UAE countries, if you want to start a business, you have to have a local person as a sponsor. So likewise, here also they said that a local advocate has to be sponsored here. So we have to open up. We can't just hide and say that, I will not allow foreign law firms to come in India, and it is a closed thing, and, I won't allow anybody to come. But to the extent and how far and how best is the most important thing. I think, they are not allowed to litigate. That's a very good thing, because I don't want them to litigate because they do not know the context of Indian culture or, the way the cases are brought it here. And, therefore, that's a good thing. But advising is very good. But the question is whether that will turn into an international hub of arbitration is a big question. Because, people still prefer Singapore or, London is very expensive. So Singapore is one of the best places where a lot of arbitration takes place. Even today, arbitration takes place, where international arbitration is concerned, it takes place in Singapore because the way it is done. Here, if arbitration comes and if the venue and seat of arbitration, or even if a foreign law firm is coming and helping us in the arbitration, what happens is unless the jurisdiction of that is with the courts, and so what happens is immediately we go and file some appeal, and we interference of the courts are more here in arbitration is concerned. It's not that completely it is taken away by the arbitration, because I've dealt in an international arbitration where 2 sovereign countries were involved. It was in Singapore. But the way the Singapore Supreme Court acted is wonderful, because the Supreme Court Chief Justice, who was on leave, cancelled his leave and said that I as a nation, I as a sovereign country cannot ask another sovereign country not to take back their land. And he said that compensation is only the way out, and therefore there cannot be any stay on that. That will never happen here. So it is better that foreign law firms should come here, but limited purpose of advising on foreign laws, and also the partnership which India Bar Council has said is very good, because that is what I feel is a wonderful thing, because even otherwise LPOs were there, and we are doing work for the foreign law firms, and a lot of people, a lot of LPOs are doing for this. And in the context of India becoming a big global economy, and we are going to be that now we are in the 5th, and if we go back to 3rd or 3rd Indian economy, that is, it is necessary to have the best practices in all over the world to come to India, and therefore we should encourage them, but encourage them with the fact that Indians should be a part of it, Indian lawyers should be a part of it, and Indian lawyers should benefit from that. And like today foreign banks comes to India, but Reserve Bank of India has said that foreign banks who come to India has to set up an Indian subsidiary company, because they cannot just one day close the door and go back. And in that Indian subsidiary which is set up in India will have to be merged with another bank in India. So that way it has to be there. So I support, and I say that what BCI has said is correct, and it is in the right direction.
So thank you, Bala, for sharing your liberal views. Now we will go to Ravi. And Ravi, so, now to implement these BCI rules, especially in the context of the A.K. Balaji judgment of the Supreme Court, which necessitates or mandates that, people who, advocates or lawyers who want to practice need to be registered. What are the kind of structural changes that are needed in the Advocates Act to implement this?
See, I think the biggest gray area, right? And in my legal experience of last 18 years, you get recognized as a good lawyer when you're able to identify gray areas and loopholes in acts and rules and regulations, right? And I feel there are certain vague terms which need utmost clarity, both on the Indian side and on the foreign side, which is what does reciprocity mean? How do we implement that? That I believe is the genesis of ensuring that there is success to having a foreign lawyers, foreign law firms, establishing their offices, setting up their workforce here in India. I also believe competition only has one output, and that output is improvement, right? Tell me one area or domain where competition has led to decrease in service. Rarely, never, right? And with this provision where foreign law firms and foreign lawyers are being allowed to practice law in India, we make this statement as a motherhood statement, but there are so many restrictions out there as well. If you have a business mind, you are supposed to make money in a particular geography. When you come to a particular jurisdiction, you see there are restrictions. I feel uh, a lot of clarity and listing out of what those restriction means needs to come out. I would also say, and you all are in the same profession, learned audience, we have a fiduciary duty. Our clients trust us as persons, as firms we represent, and the organizations we work for, and that's why they come to us for opinion. What happens is when there is serious foreign investment coming into India, the approach is two-pronged. One, let me tap into my present law firms slash partner or business partner who can help me with all my legal questions. That is the first approach that they take. The second approach is, let me get the groundwork done by a local Indian law firm. That's the usual approach all serious foreign investors take when they come to India. Imagine with these rules and regulations that there is already a satellite office, or I should say a proper office, set up by these firms here in India. So rather than all that billable time being provided to the foreign office of that foreign law firm, it'll be probably billed to Indian office of that foreign law firm. What does it mean? Increased revenue, increased jobs, increase in the retainership, right? And change management is a huge thing. Whenever something changes, there are two groups formed. One that embraces, and they are always in limited number, and one that opposes. And if you want to oppose, there'll be three logical points at least that you can pick up on. But if you are for the motion, then there are so many benefits that one doesn't talk about. I strongly feel that foreign lawyers, law firms should be given an opportunity to practice law here in India. I can also tell you there are Indian firms that just do not use Indian arbitration centers, but go to Singapore, as Sir said, due to many reasons. But one of them is, having those lawyers that they trust internationally to participate in the arbitration proceedings. Imagine if we kind of relax certain provisions, then India, because of its cost effectiveness and arbitrage, can essentially become a powerhouse, at least in Southeast Asia, for all the arbitration matters, right? And I believe the points that I picked upon, those are the things that BCI or authorized regulatory bodies should take up to ensure that there is clarity for those firms which consider India as a very important geography for them to grow their business.
Sure. Thank you so much. So before I go to Monica, I want to come back to Bala. So Bala, while I understand that, you have endorsed that is how, the best solution for us is to have foreign firms in India. But I would also like to address some of the concerns that the Society of Indian Law Firms has raised, and probably rightfully so. The Society for Indian Law Firms says that, they believe that the playing field is distorted, right? So they want to first address, they want to basically have this change. They are open to the change, but they want to do it in a structured and a phased manner. right? They want to address issues like, where there are restrictions or rules around advertising. There are law firms in India are not really recognized. They want all of those issues to be addressed first before they get on to, opening the country up for law firms to be coming in, right? So what do you think? Do you think an open consultative process would have been the right one to really come up with a harmonious law? What's your view on that?
No, I think definitely an open consultative process is the best, because I'm not saying that, somebody has to distort the thing. But mostly, I think I am not clear as to what all things have to be considered, because the Society of Indian Law Firms, of which I am also a member, has not clarified as to what exactly are the problems. They say that, some kind of a consultative process has to be there, and which is a must, but definitely the stakeholders has to be consulted. But the fact of the matter is that even today, as Ravi said, is that, when I'm dealing with a matter which requires a foreign law, which requires the implementation or, consultation process of a foreign law is concerned, what I do is, even though I'm doing it in India by an Indian law firm, I'm not acquainted or, fully aware of the foreign law firms and its implications. Just by reading the text, you don't get it to know that, practical side, what is decided, what is the practice, everything. So what you do is that you go and consult them informally, or, you consult them and get the best out of them. And then, you put it as yours. So I think a consultative process is best, but advertising is concerned, yes, they do advertise, because, as far as I'm concerned, I have experiences when something comes up in the paper about some kind of a thing, and, half a dozen people fly out and, meet us and say that, we are the best, we are the thing. But even in India also now, most of the law firms do, when they read the Economic Times or the Mint or, Business Standard, and say that some company is going to do that, they do send feelers to everybody saying that, we have done this, we have done this. Ultimately, it goes to somebody. So I think to that extent, it is very, very informally being done that, so the way it has to be advertised by the foreign law firms, I think, we should continue with the standards which we keep, because that keeps a little nicer thing. Otherwise, it will distort the practice of a lot of other law firms, and, only the certain big people, because they have experience and they can vouch for it, will come. But consultative process is a must. But again, going back, competition has to be there, because you produce a lot of young lawyers, and that lawyers needs to be aware of what is happening in the globe. And, we have, after G20 and everything, we said the world is one earth, one family. And therefore, we have to be acquainted. We have to train them. It is not that, old school lawyers are there and, they think only about, so we have to give them the training. And therefore, they have to come to India, they have to partner, and training has to be given. And many things has to be set right. But consultation is a must.
Sure. Thank you. So now I'll go over to Monica. So Monica, as you know, that the rules state that registered, so once a foreign law firm is registered in India, they can actually only advise foreign clients. There was a subsequent press release by the Bar Council of India, which suggests that registered foreign lawyers and firms can only advise on foreign and international law. Now, what this could do is that it could lead to a situation where international firms, as we said, could actually prefer, they would advise Indian clients on a fly-in and fly-out basis, especially when it comes to India-seated international arbitrations. Now, what is your thinking on the fact that if India really wants to establish itself as an international hub for commercial arbitration, would it not actually be more effective if we were to carve out an exception whereby Indian clients may be allowed to seek advice from foreign lawyers and law firms, especially on the subject of foreign law?
Thank you. First of all, that I want to say thanks to India government as India Embassy in Singapore that we got our visa very immediately in 30 minutes only, because that we stuck in Singapore, in Jakarta, the airlines, they didn't allow us to fly to India because we don't have a visa yet at that time we fly. me as the person that they give me the permit, but our team not yet, so that I must fight for our team to get the visa soon, so that we are really appreciate for the India government to issue our visa by India Embassy in Singapore. It just 1 hour after I came to the High Commission in India. I'll talk to the government. I'm very happy. Thank you, sir. We very respect with your collaboration and trust for us that we come here to get collaboration with India New College as a lawyer or attorney. First of all, Sally, we must talk about attorney and lawyer. Attorney that we must go to the court, and lawyer is for us just for the consultation. Exception for the lawyer or attorney that, of course, that we must have success experience first. In Indonesia and in America, because that we have a representative office also in Washington DC, our success experience that people will accept you, not even that India government, not even the US government, not even in the Indonesia government. But remember, you must have good reputation first. When you fight for the something that against the law, that all of the government in every country that will close your door. So that based on my experience over 15 of the 16 years, that most of the government in the world that accept me, not even that I'm not registered in the country, but they accept me and they support me just because that they know that I have a good willing to help people. So arbitration about the exception that why we must open the door to every people that want to make he or she dreams come true. Like me, I have my dreams that I want to be the world, the good attorney and lawyer in the world, so that people that can accept me. That we know that as an expert, we must fight for the good law regulation in every country, such as arbitration. That especially such as the specific case about tax. Tax it must be that we must talk about fair. Arbitration also we must talk about fairness. Why? If we got the money from the US, so we must pay the tax for the country in the United States. If we got the money from the Indonesia, we must pay for the tax for Indonesia government. If we got the money from India government, India country, so you must pay for the tax in India. So we talk about fairness. That's our history. That all the government that will hear about us, so they will accept you. So the exception that we talk about the arbitration or how India government that can make exception for the lawyer that for the foreign lawyers. Actually, that our client come from the foreign lawyers come to us. We are a local lawyer or attorney at the time. But based on our success story, that our multinational client that come to us because they know about my reputation, they know about our success story, they know that we have a willingness good to every government in every country. So that's why the exception is not only for you must have the success story about your knowledge also about arbitration, IP, tax, and every specific law. So we must know also that in the world that we know that lex specialists that have got lex generalists, we must concern about the situation. So I myself in my mind, every people as my friend, every Nicolette is my friend. I never compete with you, but I compete to make the new good regulation to the world. So that's why that I become a professor in the University of Indonesia. Why? Because the government came to us to heard about our advice. What is it? How must we must do to make a good regulation? So then we collaborate each other. So then after that one, I changed my situation to become a researcher also. So based on my success story, the University of Indonesia as one the top university in Indonesia, they asked me to teach as the professor, as the First time as a tax professor, and they change and shift, they promote me as the economic professor. So people will hurt you. They listen to you. They make new regulation. They will collaborate you. They will make exception to you if you have a good effort to all the world, to the government. Deep knowledge is a must. Professional is a must. Good reputation is a must. So just like I just talked to Indian government, so he really helped us. Just talk. Just came to the High Commission in India in Singapore just by phone. We didn't come inside. They talked to me. Visa service is not here, ma'am. Yeah, but we have an urgent. We very emergency because that I must attend the conference. So they help us. So the government they talk to me just by the phone. So I explained, this is Monica. Yes, it's me. Because that we are connected also with all of the government in the world by my alumni. So that deep knowledge and our professional history, success story is not only for the consultation. So please remember, I never compete with you, but we will compete to make the good regulation for every country in the world. So that we must keep a fairness, that India is a good right now, that the economic growth is very good right now. So this is the big challenge to India to become the reputation that international. So don't fight as the same professional. It's not bad. Yeah, I can see your smile there. So no, we are not enemy. We are friends. Trust me. That's my experience. That's my success experience. Don't compete each other with us, but compete to make the good regulation. Once you success, the government will call you, will invite you. Hey, come to my table. I want to talk to you. I want to hear what you experience. I want to know your client. Okay. So what do you want to know? So they will send you the military to back up you. They will send you the team, the goodness that to protect you too. Why? Because they know you will give the world the best effort to make the new regulation fair to every country in the world. That's why the exception only for the people that have a good reputation, with successful experience, and we have a good willing to do it in every country. It's easy for you and me to go to get in touch together in the world. How come that I can stand here, talk to you if my visa not issued yet, if my team that they stop in the Singapore, we never talk in person. So the committee also, that Monica, how good your situation are. Don't worry, I will come to India commission, High Commission, government in India, embassy in Singapore. I will talk to them. So then that they just wait. And until now, the previous one that we submit visa not issued yet. But when I talk to the India government embassy in Singapore, when I talk to him, I talk in there in person, and the people that saw me, that saw the picture, that they know you are a good person, so they accept you. But even we never know each other, I never know who is the person that who helped me. But when they help me, we know when you have a good reputation, every people will open the door for you. So the exception must be clear. Must be clear for what? This is the person that we can trust, that the world will be good for us together. That's for me, for the exception. So that's my experience and my opinion. So why America also, they make a different situation by the bar also, that they know that it's not easy for us as a lawyer in the world, as attorney in the world, that we fight each other in every country. No, I said that to my friend in America also. No, we never compete, but we make a good new regulation to the world, because the world needs us to make the good regulation. Not even in education law, not even in the taxation law, not even in the arbitration law, not even in the IP law. Why? I never agree with the plagiarism. Never. I never agree about that Tax Crime Act. Never. I never agree about the discrimination. Never. So that's why the most important thing for the law, exception for the people that have a good regulation, it happened now. Why we talk about AI? AI, all of the people use it. Why? Why we open the door for the AI? Because people feel that it's really helpful for us, not even the researchers also. So that's the point of us, that Indonesia, India, America, and also for the Europe, British, yeah, we can talk and we collaborate. So we never compete, but we make a good new regulation for arbitrage, IP, and taxation, and every law.
Thank you. Thank you, Monica. So just coming back to the BCI rules. Yeah. So now BCI has the discretion to approve foreign law firms from different jurisdictions. Yeah. And that approval can actually be refused if the BCI feels that, there is a disproportionate number of foreign firms from a particular jurisdiction vis-a-vis Indian firms in that jurisdiction, right? So there is that discretionary element that is there, right? So can you share with us, considering that you've come from Indonesia and you would have interacted with firms and lawyers across the world, and specifically in countries like China and Singapore, which have actually been models, have propagated models where through different principles, and have actually successfully garnered the representation of foreign law firms from different parts of the world in their own countries. Can you share some of your experience on that?
Okay, in my experience in Indonesia, that regulation that we didn't do that. In government Indonesia that didn't do it. But we specific that only that the person that have a high quality and deep knowledge about that specific law that can get that license. So that my opinion that if India that want that to make a balance, yeah, I can say that make balance for the people that who want that will get the license or not. So I think is number one is that the deep knowledge about your specific law that you expert in it. That's the most important thing. It's not about the quantity, but please talk about quality. The quality of the lawyer or the quality of the attorney is the most important thing, that the represent of your country too, represent of your law firm too, represent of the your university too. So how successful people that represent of the body of the law firm or the lawyer of the country that will show you that this is the right person to be to the international represent. Why? Because that based on our experience, if you talk about the quantitative, we talk about the competition lawyer in the world. But if you talk about the quality and reputation, we talk about how good the world right now for the law, for the regulation. It's just a difference. It's different perceptions. So that's why that we open our mind now. In Indonesia right now, everyone can get. We never talk about the quantity right now, but we talk about the quality. Why? Not even right now. The Supreme Constitution that give the license for the lawyer that come to the tax court. So why we should do as the tax court at the time, as the tax lawyer at the time? I never compete with the lawyer at that time, but I know only for the success attorney that you can win at the tax court, at the Supreme Court also. So don't worry about the competition, but please make sure that the law good for the world, such as like this. I have experience. This is a fun experience. Yeah. The law sometimes in the substance is the comply to the regulation. We never make a mistake. We never fail. We never late. Okay, so I came earlier to the tax court or the Supreme Court, but our counterpart they late, so they lie. They said that hey, no, the judge didn't give the oath to the tax attorney. I said that yes, we have a CCTV, but you are late. So we never compete. But we must make the regulation that's good for all. That's good for the people, the people that want to get the fairness, or also that we must that know the situation that's bad for the government or the bad for the public or bad for the institution or else. So it's not easy to the law if we talk about quantity, but if we talk about the quality, we will talk about the success story of your life, that to make your dreams come true.
Okay, thank you
Thank
so
you,
much.
Ms. Monica. We have one question from the floor for all the panelists, which is that if foreign accounting firms, that is the big four, are allowed signed balance sheets in India, if foreign doctors are allowed for operation or surgeries in India, then why not law firms be allowed for full service practice? So any of you can answer that. Hanji.
I think,
Thank you.
as far as the accounting firms are concerned, the big fours are there, Ernst and Young and PwC and all are there. But they have the similar rule, correct me if I'm wrong, somebody from them, is that they have to have an Indian arm here, and where Indians has to be there, because it is only name lending and the best practices, but it is run by Indians. I've not seen, because the banks are audited by them and, forensic audit, I think, somebody from forensic audit is also here they have an Indian arm here, but it is completely run by Indians. I don't find any, they may have borrowed the Indian best practices from outside. So I think, that can be followed. That is what BCI says, So BCI is saying is that, a lot of Indians has to be included, Indian lawyers has to be included. And that's the best thing. And, in all these things, one question which the moderator asked was that number of lawyers or foreign law firms which can come to India will depend on how many number of law firms of others, Indian law firms can be set up there, that is always there. That is there in, element of reciprocity is there. And it is like banks also, if you ask 10 branches of foreign bank in India, you have to allow 10 branches of my bank also there, that is there. And the second question is doctors as concerned, you should not consider doctors in which this, see, saving a human life, that has nothing to do with this, foreign doctors or in Indian doctors. See, if you remember about 3 years back, many of the Pope, the Pontiff, who is the head of the Catholic Church, was operated by a surgeon from India who flew down there and he operated him. It's not that, that has nothing to do with that, because, the best of people, if you have, you can do that. He was a Parsi doctor. He's still a Parsi doctor from Mumbai and who went all the way to operate him. And, as they said, when he asked the pontiff why I'm selected, he said, it came into my dreams. That's a religious thing. I don't want to go into that, So I think we should allow law firms to come into India, but a little bit with strict control over them. And one control is that, one of the questions is that, what kind of an action we can take if they violate the Indian rules. And, that is something which, we should build in. A lot of things are to be done and we should consult the stakeholders in India and we can draw up. And as we go along, we kind of find something is to be changed or something has to be bettered. We can do that. That's what
Thank you so much, sir, for answering that.
One more thing. The difference and the impactful difference is, yes, the brand may be a big four, but the signing authority is a registered chartered accountant in India. That is the biggest difference. The contention here is that we are saying, let's recognize foreign lawyers as good as Indian lawyers under the rules and regulations are set up by the BCI. And there is a kickstart to it, right? So that is the biggest difference that you see here. There is a brand, but all of them that are operating are registered in India as chartered accountants. But with lawyers, we're talking about not just firms, but individuals, right? So that is a difference I hope everybody appreciates here.
Thank you, sir.
Okay.
Yeah, please go ahead, ma'am.
For my college EY, so we always fight every year. I know that you are a big firm, and my team also did as a EY. Once your client come to us, that we never fight with you, but our client come to us first. In Indonesia, the regulation that we cannot compete to get one client each other. But once your client come to us, that EY as our friends, so we want to talk about the chartered accountant is a different knowledge with another law regulation, especially for the tax regulation, especially for the arbitration and IP regulation. So once your client get the contract, I think it's better for Big Four to collaborate with the lawyer, with the attorney also. Why? Because that it will make your client suffering so much They will hurt so much if you lose. When you lose your big four as a lawyer, it will bad reputation for you because you lost because you are not expert about the situation. So it's better for the big four as the chartered accountant or also as the auditor, as a friend. I suggest you because most of your client come to us. Why? Because they know that accountant and a tax is totally different knowledge. Arbitration also is different knowledge, different rules, different regulations. As my opinion at the first time that the professional as your success story is the most important thing, that your quality first, not as your brand, but as your quality. Once you sign the license, that they can say, hey, how about your success story? How about your incredible story experience? How about your reputation in the world? You must ask that first. So you can collaborate with the lawyer for my friend EY, because that we have EY, we welcome you also. So and every big four also that we suggest you that you must collaborate with them because is the different regulation that make the bad reputation if you lost. When you go to the court, when your client that you sign as with the big four as the chartered accountant, as the auditor, and your client lost at the court, and you said that the government is bad, your government is corruption. No, don't do that, please. I remind you, don't do that, please. Just because that you lost, you said the government is corruption. No, we never do corruption. We have high integrity in the Supreme Court and the tax court. We win because that we have a high integrity. But please go collaborate with the expert one. That's my advice to our friend at the Big Four. Then once your client not ask for the services that you are expert in the auditor and the chartered accountant, please collaborate with another professional. That's for me as your best friend.
Thank you, Ms. Monica, for this kind advice. And now I would ask the moderator to please conclude the session.
Yeah. Do we have time to take audience questions or?
I'm so
Okay, we
sorry,
are
we
out
can
of
have
time,
it
right?
over the lunch
Okay.
networking time.
Sure, sure. Thank you so much for being such a patient audience, and I hope you found this topic insightful and you had some, you could confirm, you sort of agree on some of the views that were expressed. Yeah. Thank you so much.
Thank you.
Can we please have all the panelists for a group picture? Thank you everyone for sharing your views and enlightening us with all these interesting pieces of information and facts through this panel discussion session. Thank you everyone. Can we have a huge round of applause, everyone, for all our panelists for sharing so much insights to us. Okay, everyone, I wanted to share one very exciting news with you all. One of our event exhibitors, Pro Vakil, is giving a huge giveaway, that is an iPad, for one of our lucky winner. So all you need to do is go to their booth, scan a QR code, and you'll be registered. And tomorrow, that is the day 2, before the award ceremony, one of the lucky winner will be conferred this bumper giveaway by them. So I request everyone to please go ahead and whenever you have the time, and I wish you all the very best for the same. Now moving on to our case study presentation on the topic ADR, the new era. To talk about this, I would like to invite on stage Dr. Moksh Kalyanram Abhiramulla, advocate at La Mintage Dispute Resolution Hub LLP, who's also our dispute resolutional partner. Thank you. Have a huge round of applause, everyone, for Dr. Moksh.
Okay. Before the presentation picks up, just wanted to say, like, alternative dispute resolutions has taken a big leap in the legal segment. Everyone talks about it. And everyone uses arbitration, mediation, conciliation, etc., etc. Good area of practice. But what I personally perceive is this. Why is ADR picking up? Any reason? Why is ADR picking up? If I simply put it, how fast can a civil court give final judgment to any civil case, let alone your legal succession certificates? Let alone legal succession certificates. How fast can a standalone civil court give a final judgment? Ideally 5 years. Thanks to the number of litigations and population in the country, right? There's a fundamental reason why ADR has taken the light of the day. Now, having said this, what could be the expectation of the litigant from ADR? Quick resolution. We are not saying that litigants can see resolution in, this is about us. You keep browsing that, I'll be giving the voice for it. But then the focus of the litigant is a quick resolution. The focus of the counsels is satisfied client. You can correct me if I'm wrong. The focus of the client is quick resolution. I want, if I am supposed to recover some amount, I expect that recovery somewhere to happen in 2 years, if not more than that. Now, why they have come to ADR? Because in 2 years, an award comes. Now, this award can be executed in the regular execution petition norm. That's the order of the day. But then, the second reason why ADRs have picked up is the voice which the litigant wants to be heard is actually heard in the form of a mediation. Litigant is more interested that the person who is deciding the case hears their voice or hears their actual grievance. Now, when this is it, the most relevant part which we see is the mediation, where we are expected to see the entire downpour from the client, emotion as well as factual as well as legal. Now, all this is evaluated on both parties, and in mediation, we come up with a solution which is acceptable to both parties. Mediation becomes a successful option. We end a mediation with a settlement agreement. Many a times mediation fails because settlement does not happen. Mediation shifts to arbitration. Now, having gone to arbitration, it's somewhere you have to fall on which side. So you go by the facts, or you see the legal representation, and then you come up with something called an award. This is where arbitration comes in. Now, what has happened in the new era? One is the speed which we are looking at. Second is the technology which we are looking at. Third is what is the reliance which we have on the usage of the technology. Now, let me give a small review. This is the most common areas where we see an arbitration clause coming up. Every shareholder agreement today will have an arbitration clause. Most interesting thing in this arbitration clauses, these are standard recitals. And every standard recital is prone for heavy interpretation. And this heavy interpretation is left with our intellectual thoughts. The focus of us to our client is to see that we get the maximum benefit whatsoever possible. The focus of the litigant is more on the emotional front rather than a financial and legal front. This is the first gap which we have as a responsibility to work on. We are supposed to remove the emotional part guide our litigants or the clientele properly and say, look, these are the facts of your case. This is the present legal scenario. We are expecting few changes, and this is what can happen. So in the best of interest of the survival of the company, these are the suggested areas where we have to come to final conclusion. Now, if we are advocating this to our clients, our client is 90% convinced and is aware of what could be the expected output of an ADR. This is our first responsibility. Understand the factual and legal scenario, explore the flaws in the agreement of our client, guide them that in our next arrangements, we have to see that this is addressed. And this is what can factually come out of in this particular litigation. Once this is done, the ADR process kicks in and it actually happens faster. Because we have all given the ground reality before, like, look, this is what the whole thing comes on. I'll share you a small case where these were the issues which in any SHA is there. These are the common recitals which we're talking about. I'm only going to touch base upon a minority shareholder interest, which was picked up in a particular case. This is the point which I would try to explore upon. In the shareholder agreement, whenever you have a minority interest issue, what is the focal area? Focal area relies upon restriction on sale of any asset or part of asset. And whenever an investor who has done a small time investment in a company and the company is growing, does not accept the point that any spin-off or a sale of a small product or a sale of a small activity in the company will hit his investment value. It's very difficult to convince them. Why? Because they have got emotionally attached with the company, or they feel that once this product or this leg is sold, price drastically comes down, value in the company drastically comes down. We will definitely do some max on it, but then what is required to convince the client that the spin-off or this asset would be favorable to him? Because we, as their counsel, if we say that spin-off is beneficial to you, what is the threat which we are going to have? Immediately our client may perceive that we have changed the side. Correct? So we have to strategically evaluate, give reasons, and beyond reasonable calculations, we have to explain to the client what is the most required scenario for the execution of the spin-off or sale of that product line. How do we do this? One, numbers, because numbers don't lie. Two, future prospects, how the company will look with this product, how the company can look without this product. We can take support of other people who are in that segment or subject matter experts. That's the second way. Third and most important thing, give a complete review of the legal scenarios that exist for that particular product vis-a-vis the company as a whole. Once these three options are evaluated and explained to the client is bound to take an informed, clear decision, which will help the process to complete faster. What is missing is somewhere we don't address any of these three legs. We either don't address the legal review part, we don't address the mathematical part, we don't address the future value part. Any of this is missing, we will have a hustle or rupture with the client. But when these are addressed, documented properly, that is where we have a client listening to us, sees our guidance, takes an informed decision, comes back to us time and again. And this is supposed to be communicated to the arbitrator or the mediators who are doing it. Now, when you are able to communicate this fact to the mediator or the arbitrator, they channelize the discussion or they channelize the proceedings in that direction so that both the parties get beneficial interest derived. This is the focus. Now, what we did for this was this matter was settled. Why it was settled? It was settled because we said, look, when you spin off this particular product, this product actually gives a cash inflow now. We are in need for a cash inflow. You're not and it was settled. Now, this is where we say, now this was a mediated. Originally, it came for arbitration, but it ended up in mediation. So there is a possibility always. Mediation will shift to arbitration. Again, we'll come back to mediation. Because when scores are clear, when you are communicating to both the litigants that these are the issues, and it boils down to 2 points, and people are willing to take a decision. Today, we are not, people have, over a period of time in business, initially they may have that emotional focus. But as they grow in business, if they are guided properly, emotions go down, professional decisions are taken, corporates grow. This is where we have been focusing on and saying that, okay, dispute resolution out of courts is a better option than trying to fight in the courts for 2 reasons. 1, the voice is heard properly. 2, alternatives are explored with interest. 3, people are allowed to participate and willingly take a decision. There's the reason why I think the new era of arbitration, ADR has taken a pickup. Now, there was a question which was asked. In fact, it will be asked to every person available over here. What would be the impact of AI in arbitration, or AI in mediation, or AI in dispute resolution? One good thing which I see is AI helps us rewrite our petitions well. We get a beautiful language to represent. We get a beautiful pointers to represent, but facts don't change. Once our facts are clear, for writing the award or for writing the settlement agreement, we can use AI. That will give us a better option. But for actually discussing upon the facts, it doesn't work. But to analyze the future aspects or future business tendencies, AI is a beautiful tool. There are many softwares that are available which will help us to understand the product line's performance possible in future. This will help us to take a decision and work on with the client and come up with a solution. This is what I thought I would share from my side. There is one point which I would try to say on my personal front. We at Dispute Resolution Hub are open for empanelments. We are looking to onboard arbitrators. We are looking to onboard mediators. We're also looking to onboard advocates on our platform. It's a platform where we exclusively help clients to come to amicable solutions. It's a technology, we are using technology where we give a platform where people discuss, it is recorded, documented. The entire meeting is having a video audio recording, and we synthesize it. We come up with the minutes that is shared across to every stakeholder. And finally, the decisions whatsoever are recorded and they are taken over. Now, anyone would be interested to empanel, we are here for 2 days. You can get in touch with us. This is our service area. Any questions? I'm done. That's fine. I hope so.
Anybody, any questions? I think, sir, you very well explained everything and left no chance for anyone to have any questions. So,
Yes, sir, please. Please, sir.
To get a speedy order from the appropriate court or appropriate authority is getting frustrated. If you see the current trend of these arbitrators, something like the civil courts, tarikh pe tarikh, and nothing happens over there. I'm just sharing my personal experience dealing with a lot of ADR matters in Mumbai, where a lot of our senior advocates or the retired judges have been appointed as arbitrator. Sometimes it happens, even I have moved to the Bombay High Court, seeking the timeline that award is to be passed. The court has even given the direction of, let's say, 6 months time, sometimes 6 weeks times. But the fact is that for the one or the other reason, award are not passed in 3 months' time or 6 months' time or 1 year time, something likely to be a civil court of taking a time of the 5 year or 7 year, ADR is not making much difference into that. I want to say on you.
Honestly speaking, I also echo the voice with you, but then this is a concern which is in the ADR where couple of people, I can say the couple has a bigger number, but the couple of people who are appointed as arbitrators prefer to give a date. We can technically see that they are not interested in the proceedings, but then the legislation is silent on this particular point. You can't change the arbitrator just like that. In fact, it's not that easy. From my point of view, we only pray that we don't fall in the hands of such arbitrators. But one option that we can do is, since an arbitration is in progress, we can suggest with the other side counsels and say that, hey, look, there is a possibility of mediation. Let's explore it. Unless both the councils are willing for, because I have seen a scenario where both the councils have agreed fees has gone up. Both the councils have agreed date is given. It's like that. Now, both the councils agree and they come up to certain points of time and say, okay, these are the points where we can settle off, square off the issue and mediate and close. I think that would be a solution in such type of scenarios. I'm not saying it is not happening. It's definitely happening. But when we are stuck somewhere, it's a deadlock. When there's a deadlock, the easy way to open it is shift it to mediation and see that we explore. See, at the end of the day, when both the advocates sit together, it's not difficult to convince the client. It's not difficult. We can convince on both the sides. When we could take the privilege of convincing the judges and Supreme Court judges, can't we convince our own counsel, our own clients? Quite possible. Somewhere we are not also exploring. That's what I intend to say. And the easiest way or easiest solution for the problem which you and I are facing, we are in the same boat. It is to help and shift it to a mediation.
No, I'm also saying that even before the arbitrator is appointed, a lot of time is being wasted for the appointment of the arbitrator. The fact is that in some of the agreements that we have signed, both the parties have agreed for a particular arbitrator in case of the dispute or differences arise between the parties. But when the difference arises after 2 years, after 3 years of the signing of the contract, the one of the party moves to the court that, to have the appointment of another arbitrator for that matter. There itself, 6 months time or the year time is being wasted even for the appointment of the arbitrator, because one party is agreeing, other party is opposing, and then it goes on and a lot of time is being, whereas in the agreement itself, it is already named Mr. XYZ. In some of the cases, I remember having been, both the party agreed for Mr. X, that Mr. X would be the arbitrator in case of any difference and the dispute arises between the parties. But at the later date, when the actual differences arises, one of the party moved to the court for the appointment of another advocate, and a lot of time is being wasted even into that.
I'll address this issue,
Thanks.
sir. When the agreement is signed, people are in good terms. People like each other. You want to do business together forever. That's the attitude when you sign the agreement. And many a times people don't keep the copies also. But when a difference comes, difference is in everything. The best way is when you are writing 90% of the agreements are driven by Google or AI. If these agreements are written professionally and these agreements have a scenarios where instead of writing the name of the person, we write the qualification of the person. I have seen agreements which are related to construction management. They talk about or they name a person. The person has zero knowledge about construction management. This person gives an arbitration award. That award is set aside. The mistake is we wanted to write someone's name. Rather than writing someone's name, at the time when the agreements are being written, you quantify the personality who can be an arbitrator. You quantify the personality who can be a mediator. Once this is done in the agreement level, you have actually helped the client to see a forecasted dispute that never arises. Because you know that this kind of qualification, this kind of experience, this kind of expertise is you are going to choose as arbitrator. At that point of time, it is difficult for court to appoint also that such person. Because immediately when you go to court, file a section 11 petition, what would be the result? Retired judge so-and-so, see from the list, appoint. Now, when I have such and such clause, I would immediately say, sir, this appointment does not adhere to my conditions. You please explore. Now, court will also take a time and you will get an arbitrator who is also aware that he is chosen by some selection. Now, this selection is something which current agreement, I have seen a couple of agreements being written like that, but this agreements must come, this type of clauses must come in every agreement so that it becomes easier to address the issue. I think I have addressed the issue, sir. Thank you.
Thank you so much, sir, for such a great session. Please, everyone, have a huge round of applause for Dr. Moksh. Thank you, sir. Moving on, it's time for the third panel discussion, everyone, on the topic corporate governance and compliance, navigating regulatory challenges. For this, I would like to welcome on stage the moderator of this panel, Mr. Arpinder Singh, Global Markets and India Leader at EY Forensic and Integrity Services. Mr. Arpinder Singh, everyone, please have a huge round of applause. Our second panelist, Mr. Srijit Mukherjee, Director Legal at HCL Technologies Limited. Please have a huge round of applause for him, everyone. Our third panelist, Mr. Sameet Gambhir, Vice President and Company Secretary at DCM Shriram Limited. A huge round of applause, ladies and gentlemen. And last and fourth panelist, Mr. Kaushik Mukherjee, President, Legal at India Bulls Housing Finance Limited. A huge round of applause for all our panelists.
Thank you so much. I think we'll start because I think we are the last session before lunch. I can tell you, hopefully, the panel is interesting.
Better than the one after lunch.
Okay.
Certainly. I mean, I've done a lot of these, sorry to cut you, but I've done a lot of these sessions right after lunch, and that's a disaster.
Okay. So we'll take Kaushik's view on that. But coming to it, I think we have a very good panel today. As you can see, you have lawyers with a lot of experience from different sectors. You've got Kaushik from India Bulls Housing. You've got Sameet, who's from DCM Shriram, which is more traditional, more conventional. Then you've got Srijit, who's worked at HCL Technologies, which is a large, obviously, tech powerhouse in India. So I think it's good is we've got different industries. And I think we can maybe get a different perspective from all of these sections. Today, we're going to pretty much cover compliance and governance. And I'll put the first question to Kaushik. So Kaushik, given the current conflicts across the corporate landscape, organizations often struggle to create a balance between the different dynamics of the stakeholders and shareholders. And I know that's an area which is very close to your heart. So if you can just explain that in the light of corporate governance and compliance, I think that'd be a good start to the session.
Sure. No, thanks a lot for that. And thank you guys for getting me here. So let's just dive straight into the question. So it has been a perennial question in corporate governance, actually, that should we go with a profit maximization for the stakeholders, shareholders specifically, sorry, approach, or should we, which is actually between the 80s and the 90s, that was generally the approach to corporate governance is, try and maximize profits, do your best for the company, return value to your shareholders in the short run, without maybe not that much of thought in relation to the long run. However, that traditional approach has slowly but surely, there is a move towards creating a organization that is looking to actually maximize the value for all its stakeholders and not just the shareholders in the short run, but sort of inculcate a culture in which there is more transparency and there is a long-term and gradual approach. So what this does is, and what we've traditionally seen in the past, that has been replaced by now a full governance framework, which also I've had the good fortune of seeing it evolve over the years. And I can tell you, I mean, this is a question open for any one of you to also come up with your views if you would really like to do so. But I think that the better approach is an approach in which the laws are tailored in such a way that governance is transparent, that there is good governance, there is sort of responsibility for the decisions that are being made. There is a process in place, which sort of what it does is it mitigates your tendency of taking decisions which we misfire in the long run. The idea is to make gradual progress instead of doing it all in a day.
So just not to put you on the spot, Kaushik, can you explain this in light of one or two instances which has been happening in the market? A lot of this shareholder, stakeholder disputes are very evident in the newspapers. Can you give one or two examples? And
Yeah, so of course, what everyone I think has been reading about the Byju's sort of situation that is currently that is evolved, and ultimately it led to a ouster of of the promoter, controlling person in control. Of course, promoter is more Indian concept. It's internationally understood as the person in control. So perhaps and this is what we have seen in a lot of these examples, is that the interest of the controlling shareholder or promoter, as you would like to put it, and the interests of the long-term interests of the company may be divergent at some stage, which is what is now leading for lenders, for other stakeholders to come up and get rid of that controlling shareholder and that control and move towards a more transparent sort of a system. Byju's is one. What happened to the Z-Sony merger is another example. So I guess we are seeing instances in which governance is being there have been positive moves towards good governance. Let's put it this way.
yeah. So I think that's a great point raised by Kaushik. I'll just add one point to it. Based on all our experiences in forensic, I can tell you it's always getting a lawyer who hasn't drafted a good contract at the time when an investment has gone in, which leads to a lot of work for us. So my request is you continue to draft bad agreements. It's good for my business because there's always some dispute or there's some rush to close the M&A transaction and the business people put more pressure on the legal team. You get a contract which hasn't got all the right terms and conditions. We really have a lot of fun with those type of contracts because it leads to arbitration, as was mentioned in the earlier session, and it leads to a lot of forensic activity. In fact, we find now in forensic activity, when the private equity is invested in a company, we sometimes don't even get access to the company because the contract is so badly written. That means that the shareholder has no authority at all to get access to the company, which we saw in the EdTech company, which was referred to earlier. And I think in some cases, they don't even ask for board seats. But then 2 years later, they're crying about not getting the board seat. So when you're investing in a company, you have to think through all the 10 things which can go wrong. And as long as your contracts are very well drafted, the investments are done correctly, I think that's the time when you really have an upper hand. So always better to take a little bit more time and then invest rather than jumping the gun, is my personal view as a non-practicing lawyer. But I'd like to come next to Samit. One of the questions we've seen is this whole GDPR data privacy. Now the Data Privacy Act has come out.
Right.
It's made investigators like ours our lives miserable. In the old days, we used to ask for the cell phone and start imaging it, saying, boss, what WhatsApp have you sent? Look at this text message. Then there's a lot of information. Anybody who tells you that when they take a cell phone and image it forensically, you can segregate personal and corporate information is very difficult. Humanly impossible. Okay, I'm technically telling you that. So I would say, Sumit, how do you comply with data privacy in the light of new compliance in corporate governance? Over to you.
Oh, thanks, and thank you, LexTalk, for having me here. I think it's a very, it's very ongoing debate as of now because the law is yet to be enforced, and we are still expecting the rules. And I think there's a lot of gray area, but I think the devil lies in details. Actually, this is what we are saying. And so in terms of preparation, if we really say from the in-house counsel perspective, there are many things which are still, still we are thinking that how to go about it, what will be the final rules in that. But some of the issues which, as a preparation, when we think is that one is that the awareness and the training among the employees and the stakeholders, because India is a country of, now we understand that 1.4 billion people, and everywhere you have stakeholders, everywhere you have public dealing with the organization, and you have the data. So I think one is that training and awareness among your employees, because you can't do it alone. So compliance function cannot do definitely alone. So it has to take, it has to be a combined effort of IT, compliance, then business people, then risk, internal audit, everyone. So I think, in terms of training, awareness, it's very, very important that this is something which has come now, and we have to be very, very careful. Everyone needs to understand this law. So this monitoring and training is very important. That's one way. The second thing is, uh, one of the area which we were just thinking in our organization, kind of organization, like we have sugar mills and we have, agro-related businesses and all. We deal with many millions of farmers and the other people around the country. When we advise them about the good crops, we advise them about the other things. We are connected with them on the WhatsApp, we are connected with them on the SMS messages. We tell them about the crops, we give them ideas, and then there are a couple of interaction we do, and to help them, not only for our sugar mills related farmers, but other agro products also. So we have millions of data for the farmers and all in the rural areas. So one obviously the challenge area would be that how do we take the consent of all these people? How do we make aware all these people? How do we tell them that this is now is a requirement, that we have your data, we have to take your consent, and then to make them aware of all the things. So this is a massive kind of a preparation we need to do for all these things. Then thereafter, there's nothing which is provided as of now. There is nothing which is there, but of course the rules will tell that, when to report the breach, where the certain guidelines are already there. They have to, they when to report the breach and other things. So there shouldn't be any overlapping, or there shouldn't be some contradiction in that, I hope. And then who can be the DPO, for example, significant fiduciary, agar hum hai, to who can be the DPO, whether the CIO can be the DPO, whether the legal head can be the DPO, CRO, internal audit can be DPO, or there will be a different qualification, separate qualification for a DPO, what kind of experiences a DPI need to have, what kind of a role of people that, and then, a couple of other things like, uh, there's a penalty, huge penalty on the violation, but what the user get, nothing. I think, the people are talking about that, if my data is stolen, my data is compromised, what do I get actually, so there are many challenges which we are debating in house perspective. And of course, till the time the rule comes in, there's a lot of issues which will be settled, I think, once the rules come in. And I think there will be a lot of help for the technology, and AI will be required in these areas. And so a lot of IT work will be there, definitely, no doubt about that. But I think from that perspective, people have started preparing. Well, we are even thinking, preparing for the case laws, like on the basis of GDPR. We're taking instances from the GDPR and telling people that this is what has happened in the GDPR scenario. So you should be better prepared for that, and which can happen to you once the rules come. And so I think a lot of work to be done, frankly.
One thing is for sure, just to sort of give another perspective to what is being said here, is that if you have contracts, all of them will have to be rewritten, and you will have to basically get those contractual consents upfront.
Absolutely.
Otherwise, you're in for trouble. Now, that is for the prospective ones. Now, what happens to the already existing ones? Why are they going to agree to, at the middle of the course, suddenly change the contract and give consents for you to do something or not do something? Unless, the counterparty to the contract, you give them something, some incentive, something to do that. So that is going to be the challenge, really.
So I have a question to both Sumit and Kaushik, as they seem to know a lot about data privacy. Without the rules coming out, do people still have to comply with the act?
I don't think it's
No.
it's in
Till now it's
effect
not notified,
It's not
actually.
notified yet.
That's what I thought.
the banks
I
also.
want to mention the RBI has notified it for the banks.
Okay.
So based on the industries you work in, I feel it's been notified in different sectors, even though the rules have not come out. So at least my non-legal view is that though the rules are not there, at least in
You
some
have to
sectors,
start. You have to start.
You have to start the
looking
journey.
at your processes. Yeah.
Absolutely.
We've already started. I can tell you, we started about 3-4 months back.
Right.
And I think people will have to take steps. So
Yeah, the preparation was in full swing, actually, because we
Okay.
know a lot of things is to be taken care in that.
We
There's a lot
haven't
of
heard
things.
from you, Sumit, so that's why we were curious. We thought you'll get in touch with
Are you from
EY.
EY?
I'm joking. I'm joking. But so let's go to Srijit. He's been waiting on the side to quickly get into this whole technology discussion. So obviously, Srijit, if you want to add something to data privacy, obviously being HCL, you've always complied with GDPR, I assume, before even the Data Privacy Act. But talk to me a little bit about the data privacy as well as the ethical use of AI. I'm sure you create a lot of software for your clients. And what is AI? Responsible AI is a concept I keep hearing. I don't know much about it. So I'd love to hear from you.
Sure, Arpinder, and thank you so much, LexTalk, for inviting me. In a jiffy, of course. I wasn't the original plan, but
You'll have to keep it.
Okay, so AI is something which is at the heart of most of the organizations now, specifically the technology-based organizations like HCLs, IBMs, and Accentures of the world. So it's still at a very nascent stage, what I would say, Arpinder, and we have to do a lot of things, and a lot of processes needs to be put in place. A lot of thought process needs to be given to the fact that the AI, generative AI, could be actually implemented effectively and efficiently in an organization. I would, from the practical perspective, what I have sensed in my organization, of course, there are certain nuances which needs to be taken care of. The first and foremost important nuance is, of course, the biasness towards data. What kind of data sets or what kind of data subjects actually are we using in order to improvise on the AI mechanism or AI platform that we already have? So there is definitely some kind of a biasness towards data. Data cannot be uniform across the subjects or across the geographies or wherever we are talking about. Even the algorithms that is being used to generate those AI and the outcomes of the AI needs to be looked into from the curation perspective. It needs to be curated to effectively apply to specific sectors or specific stakeholders for that matter. One important aspect is, of course, the privacy concerns. Now, AI, as we all know, that uses a lot of and relies on a lot of personal data and confidential data of organizations. So what happens to the privacy concerns? What happens to the data that is being used by AI to generate the outcomes? So these things are to be looked into from a pragmatic and control perspective in order to make full use of generative AI in any organization. That's my personal thought process, and with this thought process, I do try to implement the AI techniques in my legal function as well. So we are in the process of automating, the first cut review of contracts using AI. Now that needs to be. I mean, the bottom line is that what I feel is that in order to make AI work efficiently and effectively, you have to make that AI intelligent. And that is a manual effort that needs to be put in, in order to make that work effectively. Apart from that, I think there would be concerns around the regulatory requirements and the compliance requirements around the use of AI, and of course clubbed with the GDPR thing, which is now coming up. So I think holistically, if we have to look into all these factors, the crux of the entire implementation mechanism of AI in any organization is to basically address the factors of data biasness, algorithm biasness, privacy concerns, regulatory and legal compliance that needs to be put in place, and the explainability factor as well. So AI flushes out decisions. Now, how far are those decisions explainable to the person who is actually driving the outcomes of that AI, who is going to use that outcome from the AI? So those have to be backed by solid rationale and solid reasoning. rather than just a robot, flushing out outcomes or flushing out details in an input-output mechanism.
I think very well put, Shudit. I think one question I've always got on AI, because the AI requires data, right?
Correct.
Suppose if you've used a lot of data at HCL of employees to build a legal tool or third party, then that third party says, I want to withdraw my consent. And that information has been used to build an application. Will you redo the whole application now because I've withdrawn my consent? It's a tactical question, but I would love to.
I think it's a technical question as well, because the app or the tool must have that functionality of removing the related data when a person or an organization withdraws its consent for the data that needs to be used for processing activities. It's more of a technical part, but then yes, when we develop a tool for a customer or when we develop a tool for our in-house use as well, we do factor in the 8 principles of GDPR that are in place. In case the consent is withdrawn by any of the users, then there should be a functionality where we can actually restrict the usage of that data or that particular specific user's data.
Okay, thank you so much, Srijit. One thing I'd like to just mention for the audience, somebody showed this to me in my team last week, that there's a fantastic responsible AI kind of sample policy on the Niti Aayog website. So if any of you are struggling to figure out what is the right responsible AI policy, the government has already come out with one, good one to look at. I give it to all my clients and charge them 5 lakhs each. So it's good document. So let's come to, and that's not what lawyers do, right? They don't copy paste. But anyway.
I just want to ask that lady, because you're saying that RBI has given some instruction to banks. Okay. So is that to all NBFCs also, to RBI? Because I'm not aware of it. Yeah. Correct, because I'm not aware of it.
Okay.
And advisory basically for DP Act or otherwise data protection as per se?
Email is put out telling that bank should follow the guidelines under DPDP Act. This is the only simple advisory given. It's not a notification. Implementing, that's all. It's not a notification. Based on that advisory, I think IBA also issued some mail advisory to banks. It's not a notification issued by RBI, nor by IBA.
And to other NBFCs also, or only for the banks?
It's only for banks.
No, I don't think anything has come for the NBFCs, but see, I guess it just goes with that whole process that it'll take some time for you to make the switch. And for the banks, considering how huge their databases of customer information would be. So I think
the moral of the story is start the journey. The journey will take a long time.
It will.
And I think everybody's kind of started the building blocks because it'll slowly happen. We don't want a situation like one of the fintech companies where RBI comes, does an audit and, which was my next question to Kaushik actually. So Kaushik is in the hot seat because he's the only one from NHP/NBFC, whatever the legal thing is. I'm not the FS expert, but Kaushik, a lot of regulatory pressure on the financial services industry. I think one of your peers is in the newspaper on a daily basis. Question is with RBI, NHP, SEBI, IRDA, there's so much guidance coming out on compliance. One is, how do you keep up to date with it? That's my first question. But as a follow-up to it, the whole SEBI LODR requirement, a lot of financial services companies are also listed. How do you, as a legal head, keep up to date with disclosures, make sure they're adequate, not delayed? And we now know compliance can have a significant impact on business. So your thoughts?
So, so there has been this company has been around for a while, so there are processes in place, right? I mean, it is only incremental stuff that comes up that you have to analyze, and at the end of the day, there is a whole team that works on these changes as they come out, and then ultimately it is taken to legal, and there is a whole interpretation done, which may actually affect your policy. Your internal policies and your internal processes in place, it may affect that. So there is there has to be a whole process in place to do this analysis from when the change comes about. I think as Arpinder rightly mentioned, that there are multiple regulators. it is not always easy to keep track of everything that happens. So unless, and especially for larger listed companies who are also in the finance, so the finance sector, and I used to be with a law firm in international law, US law firm in London for many years, and basically what I can tell you is that unless these processes are placed, and that is the same everywhere, you will falter. And financial services is regulated everywhere in the world, whether that is in the UK or under FISMA, or basically in the US, or wherever it is, financial, and in India, of course, with the RBI, which is actually a very proactive, which has become a very proactive regulator, and more proactive over the years that I've seen. So there is no option. You cannot non-comply. You should analyze changes as they come in and have specific teams within the organization. So there will be some that deal with SEBI, some that deal with the RBI aspect. There's NHB. Now, even for housing companies, the RBI directions as they came in 2019 is actually the mothership, so as to say, the prudential norms apply for housing finance companies as well, which are under NHB, under the NHB umbrella. So all of these, it is a challenge, but what is the choice, Pinder?
I think my biggest thing to most companies 10 years back used to be that do you have any fraud in your company? And that time people used to say there's no fraud in our company. That part we kind of crossed over, a few years back, where people at least started saying we have fraud, because I used to always go to my statutory auditor, which also is part of EY, and say, this company says there's no fraud, so I think we should do more work because I think this is high risk. When anybody tells you I have no fraud in me, I would definitely do more there. Same with, I think, regulations. I think the latest news has shown that people always thought compliance should be understaffed, compliance should not be invested in.
No,
But
that
circle, I think a lot of companies, and this is my personal view, obviously larger companies will spend a lot on compliance. There's some companies which may not. And I think the lesson learned is compliance can really impact your business. So be cautious, especially in a regulated industry, that you have to be ultra conscious in that sense. Sorry, you were saying something.
Yeah, so the margin for error is very, the thresholds are very low.
Right.
So unless you're on the ball, clearly, you'll be in trouble.
Yeah.
And also the important thing for all, the legal counsel, and particularly the youngster, I always tell them, is the compliance or the legal guys. The first thing you have to understand your business, before you because particularly when you are in conglomerate, when you are a big organization, unless and until you understand your business well, it will be very difficult for you to manage the compliances, to identify the risk and all. So I think first few months or first few years, I think everyone has to really understand the business, the nuances of the business, talk to the people, interact with the business people. I mean, somehow somewhere we see that, oh, it's my job, yaar. मेरे को अपना legal का देखना है. I don't care what is happening there. No, but I need to be careful that मेरा काम ठीक है. But I think gone are those days now. But you have to be really on the top of every business, and you need to understand the things and nuances of the business.
See, on something very interesting that you touched upon is that the role of legal or general counsel or head of legal, that the terminology differs from organization to organization, but the position is more or less the same. Whatever you may call it, that role has significantly expanded over the years. So clearly, you can't just say that this is only this little bit is all that I will do. Some cases which are getting litigated, I will sort of go and liaise with the solicitor and the senior counsel and get this done, and that's the sum total of all that I do. That has significantly changed. There is no scope for that.
एक चीज जरूर मैं बोलूंगा कि everyone tells us that you are a business enabler now. Legal counsel are the business enabler. And of course we need to understand the business. Everyone need to understand the business. Then only you can do the real compliance or the legal thing. But we don't have to forget that we are paid only for our risk management or compliance or legal duty. Tomorrow, if something happens in the pressure of business, you're doing something. Enabling business is a different thing. But under the pressure of business or something, if you're doing, tomorrow thing will fall back to you only. So one has to be very clear distinction in between that, you know.
Yeah, so basically the role is one of being a watchdog and sort of ensuring that everything is in order. That is the primary job.
I think it's not just the watchdog part, Kaushik. It's something more to it as well. When you identify certain elements as being a watchdog, you also have to, advise the management on the solution part of it as well.
No, of course. I mean, that goes hand in hand, but
Yeah.
at the same time, so there are always these two buckets. Ones that are solvable, ones that are not
Correct.
solvable have to be rejected. So yeah, I mean, that's part of the process.
Absolutely. Agreed.
So this is a perfect example, my panel. When you do a compliance panel with MBAs and CAs, they follow all my rules. When I'm doing it with lawyers, they don't follow any process. But they say the right thing, that we must follow the process. I'm joking. But coming back to, Samit, one question. There's obviously this whole concept of ESG. Everyone's talking about sustainability also as a compliance. So I think compliance just keeps expanding itself. I feel every year there's a new compliance which comes up, which is kind of there. Now you have ESG compliance. So there's something called the Advertising Standards Council of India, which came out with a greenwashing to prevent greenwashing. So greenwashing, for everybody's knowledge, does everybody know what greenwashing is? How many raise of hands?
No.
Lawyers? Everybody should know about it. But anyway, greenwashing is where basically you misrepresent the facts. ESG facts sometimes don't come from the books of accounts, right? They come from what you're doing in social responsibility. And obviously, greenwashing is something in India, the ESG journey has just started. So obviously, greenwashing is a new policy which came out, which was very interesting for me, that a government body would actually, or a public body would actually come out with a standard saying this is what we do against greenwashing. So maybe Samit, what are your company doing around ESG compliance, CSR compliance, as you work a lot with farmers and you're right in the middle of it?
So I think you have touched a very, very valid point, because that's a hot topic today. And I think in listed entities, particularly, we have this BRSR report, which is nothing but an Indian ESG. I think ESG is something which is going to stay here, and which has, it has an impact actually. It's not at a global level, but a national level, government level, organization level, even individual level. I will say that it has to start from individual level also. You and I also understand that, for sustainable things, we have to change our habits, we have to keep our habits, we have to monitor our day-to-day habits, that, we are contributing or not. But I think from the corporate perspective, I would say that there is a lot of compliances now. If we're talking about ESG in India compliance for listed entity, it is BRSR, which is by the SEBI. And SEBI has really, given a detailed report now. And recently they were amended also. They have included a lot of things based on the 9 principles. And, there wherein you have to give the data. Now, they are also coming up with BRSR core. They have come up with core means, you have to give the KPIs also. And then at the same time, you have to see your channel partners upside, downside, how they are doing this kind of a thing. So I think compliance of BRSR or compliance of ESG is actually very, very critical thing in organizations. And definitely it has to start from a board level or a committee level, because unless and until this is taken seriously at the board level, it's not going to happen. Plus, as a general counsel, or as an in-house counsel, or as a legal guy, our role is definitely for the greenwashing, what I'm saying, because एक race लग गई है ESG में ना. Everyone is trying to put the data, and because you have your data in public domain and people are organizations ranking you, giving you rating on the basis of your public domain data. So now everyone wants to give very, rosy picture in those BRSR report and then people. So that's where the role of governance and compliance comes into the picture, that the report has to be reviewed by the legal counsel and to the board of directors. And most of the companies have ESG committees also now. Otherwise, we have risk management committee, for example. So it's your responsibility to see that there's nothing called as greenwashing, nothing called as a misrepresentation which you are giving, because that's very detrimental. One is that, and greenwashing means, you are misrepresenting something which is, and at the same time, SEBI is also very proactive now, I'm telling you. I was reading somewhere that US में SEC ने task force बनाई है to catch hold the greenwashing in the reports actually, and they have caught certain people also. So one has to be very careful that it carries a lot of risk in case you are giving any misrepresentation or giving any false report in your ESG or BRSR data. So greenwashing has to go. And interestingly, the point you raised, Arpinder, is that ASCI wala. That's very interesting. I was also surprised to see that last month, I think ASCI came out with the guidelines, no greenwashing in the advertisements, etc., etc. And very, very interesting. You know, what happens is people used to tell you, yeah, at your own level, what are you doing? I'm investing in ESG funds so that, I can do my bit. So people say, even if I can't do anything, I'm buying something which is eco-friendly. I'm buying something which is, ESG or something like that. Now one has to really see that the advertisers who are advertising, this is an eco-friendly product, this is a green product, this has used less carbon, this has used less pollution. You have to be substantiate with that. You can't claim that in your advertisement. That's what and ASCI के ruling को Supreme Court ने भी कई बार बोला है कि yes, you have to apply for that. So I think that's very important for all of us to understand. एक डाबर का केस था शायद किसी हेल्थ ड्रिंक का, आपको रिमेंबर होगा, everyone should know that, बीटा, डाबर बीटा. It's a very popular case wherein they said that no other drinks prevents the immunity like this. That means you're saying that no other drink in the market is good as the Daba's drink, which I'm saying. So उसमें वो काफी issues होते थे, but ये जो greenwashing वाला आया, that's very, very relevant, very important. Now everyone has to be very careful, and as a compliance officer, a compliance person, you need to sit down with your communication team, with your brand team, marketing team. You need to understand that no such claim is being in the. And even if you're talking about the emission mera low ho raha hai isme, then you have to prove that, within 2 years or more than 2 years. If it is less than 2 years, then it's okay. So everything has to be clear, to be backed by everything. Otherwise, there'll be challenge and there'll be inquiries about the ASCI, and the ASCI has full power nowadays. Actually, though it's a voluntary, self-regulated organization, but has got a lot of powers in terms of, because it got a lot of recognition in various cases. So this is a very welcome step by ASCI, I think, because everyone need to understand. आज की डेट में मार्केट में आप जाओ, ग्रीन प्रोडक्ट और ऑर्गेनिक के नाम पर दुनिया प्रीमियम लेकर के बेच रही है आपको, एंड यू आर बाइंग इट. Oh, it's a green one, it's an organic one, it's a less pollution one, it's this one, that one. And I'm saying, oh, I'm doing my bit at least for the sustainability. But that's not true. It's not happening. So I think this is very, very important, very relevant guideline issued by them. And I think everyone should follow that.
And I think just to add to what Samit said, I mean, from the non-advertisements perspective, even when we, as an IT company, when we see our transactions with our clients and customers, they are also quite worried about the ESG compliances by organizations, by service providers. They have now started putting in clauses in the contracts which actually gives them the right to terminate outrightly in case there are any greenwashing kind of activities.
So, and also this is, when you're talking about the channel partners, SEBI has smartly done it. Indirectly, it is applicable to all MSMEs kind of a thing and other private limited companies also. Because tomorrow, you have to take a confirmation from your upside or downside channel partners or vendors or customer that you are actually complying with all those things. Or you at least collect their data and you try to understand that what they are doing. Now be careful that when you have to do business with a listed entity, you better be careful, because unless you are doing all these compliances, you're not taking care of all these things, listed company may terminate your contract also. So this is absolutely, and it's not going to go actually, and it's important also according to me.
I think that brings up a very good question. We said is about signing contracts. You could be a large company signing a contract with a larger company, or you could be a small mid-sized company signing a contract with a large company. Everybody is now putting ESG clauses very smartly into the contracts. You are, without looking at it, saying yes. But when they come to audit you, don't cry when your contract is blacklisted, because then the market knows you are blacklisted, and very few companies will then onboard you because you are a blacklisted ESG company. That means a company which has violated ESG norms. So be very careful as big companies force these ESG norms down your throat. If you're not ready for it, you should be candid about it, I feel. Because I'm finding very serious repercussions, and it can really impact you if you sign these contracts. Srijit, coming to me, I know we're coming to the end of our session. A little bit about you use a lot of technology for legal tech. Any thoughts on the future of using technology for compliance and legal? Is the world evolving? So your thoughts on that, and then I have another question for you, but you can start with that.
Sure. Definitely, technology adoption is one of the priorities of organizations, and more so an IT organization. So we, on a regular and routine basis, we do look for adoption of technologies where we can make lives of our employees easier. From the compliance perspective, yes, since we are present in 60 plus global countries now, definitely we have centralized systems which are driven by technology, a hybrid model of technology and manual intervention to manage, the compliance requirements of various countries where we are present. We are slowly moving towards automating some bit of it, also taking the assistance from experts available in the market, the third-party service providers who are available in the market in order to, monitor in a routine manner what changes are happening at the regulatory and legal compliance level in various geographies that we operate in, identify those changes, and then, try to recommend ways how do we make ourselves as an organization compliant with the requirements that are in the specific geographies. So that's how we are adopting the technology slowly, and we aspire to not to replace manual efforts by technology in the future, but yes, just to complement the manual efforts and just to ease the lives of our legal team.
And just
more.
one more question on that only. When you operate in so many 50 plus or 80 plus countries, how can you centrally manage the law? India, I thought all the lawyers are common law, whatever. And how do you comply with US laws and Swedish laws and UK laws sitting out of India?
So
is that difficult?
It's not sitting out of India, but we have a global legal team. So we
Right.
have regional lawyers also who are operating in various geographies. So we take the support and assistance from them also in order to understand what are the legal requirements. Because my organization is headquartered in India, so it's driven from India. But again, with the assistance of the regional lawyers and also external law firms at times if we need to.
Okay, no, thanks for that, Shri. Now, coming to my end because it's 1:05. So, last question is starting with Kaushik. What advice would you give legal and compliance professionals? Would you say they should upgrade their knowledge around technology, around AI, some of the common risks? You have new regulations coming up which are non-technical. You have technology coming out, AI. I think some of us should go back to school, maybe. I don't know your thoughts, Kaushik.
So I guess it's just in keeping with the times, Arpinder. And so, see, it differs from industry to industry. In the industry that I work, which is mortgage lending, so technology and AI doesn't have too much scope in terms of fraud detection. Ultimately, it is all of it is secured by property. Property has to be, there is a process, manual process that has to be undertaken before any loan is disbursed actually. And that involves a title check, a title verification, physical verification of the property, valuation undertaken of the property. So basically, I guess it is the business that you're in. In mine, Arpinder, there is not that much scope. But for these guys, for instance, HCL and I don't know about DCM and your business and whether it actually affects in a long way. But if you're, so I would say that if you're doing small tickets in an NBFC kind of a situation, if you're giving small ticket size loans, personal loan type of products, so there has been a lot of advancement in which AI has actually come in, helped in detecting fraud. People have upgraded their systems, and they are largely driven by all of these technology-driven processes, which actually help them. And then, of course, legal takes its course, which go hand in hand. But the whole detection system, the whole system of origination, which is on an automated level. Now, we say that our home loans are also automated. End to end, you can do in your phone or in your computer or whatever. That is just not true. There is a whole other process that needs to be happened once you've submitted all the data. So there is only that much you can do in our industry, but there are others that I keep hearing in these conferences and in other places that it's significantly impacted their lives.
I know the lady's there as a monitor, but maybe, ma'am, you can give us 1 minute more so I can go through Sameet and Srijit.
Sure, sir, sure.
So Sameet and Srijit, last comments from your end, if you don't mind, one by one.
So I think definitely we need an automation. So we have done automation in all the compliances because we don't have much international compliances except few. But for our all businesses, like we have 8-9 businesses in India all around the pan India. So we have done the automation. We have taken this a tool from a third party also. We are very well monitoring that. Every business people, we have done a lot of exercise. I think 2 years have gone to tell the business people, explain them about the compliances. How does it work? what kind of a systems, what kind of a things will be required, and then how to. Then there are, because as a company secretary, I have to submit the compliance certificate to the board every quarter. Also, it's my responsibility directly, to understand also. So we have actually taken a tool. We are doing it automated, and we are also. In terms of insider trading also, not only statutory compliances, but SEBI related compliances and other, related compliances. We are actually working on a tool, and these are actually doing very fine, frankly. And there's a requirement. I think everyone needs to later or sooner adopt the technology for compliances.
That's sorry, if I could just, that is, that is really interesting. So is it like a database that you keep and of all employees with trading data, or how do you do this with?
No, I'm talking about the statutory compliance as of now.
Okay. So filing your form. Okay.
No, not only that, but all the industry related compliances and all.
No, insider specifically. You said insider.
Insider, yes. Insider, there's another tool we have taken. Okay, you're talking about the insider. Insider, yes. It's very difficult because you have to identify 400, 500, 500, who are the people, designated person in your company.
Correct.
So take the data of all the designated person. That's a requirement, and every year, and then whenever there is a change, you have to disclose your name, your family name, your PAN number, your number of shares in the organization. That is put in the database, and then every week you monitor it, and then if there is any
there's a
changes.
SEBI law now. So basically, I've been 20 years part of various law firms. This was my practice area. So basically, you have to maintain a database now. It is especially around transactions and material events. That database has to be strictly maintained with all of this data. And
अभी तो मतलब even if it is a UPSI, not even gone to the publics, you are discussing something, you have to maintain a database which cannot be tempered at all, with the timestamp and everything.
Yeah. No, thanks for that, Samit. Maybe Srijit, last comment.
I think few last comments would be, I would definitely resonate with the fact that adoption of automation, AI is definitely the word and requirement for the day. But then we as an organization believe in the philosophy that, we should be susceptible to, bespoke adoption of AI, if I have to put it that way, possibly targeting those tasks where specifically from the legal team's perspective, those tasks where there is minimal application of mind of a lawyer. We might look at automating those parts of the process flow, so that the lawyers can actually focus more on their core competencies, where they apply their mind and add value to an organization. So with this in mind, slowly we are moving towards adopting AI and automating things and tasks.
No, I'd like to thank my panelists before the lady actually physically throws us off the thing. But I think compliance is the future. I think lawyers have historically liked to be proud litigators, tax lawyers. But I think compliance is the future. So my recommendation, all of you, spend more time on compliance. It's good. It's good business. Thank you so much.
Thank you, gentlemen, for putting up such an interesting session. A huge round of applause for all the panelists over here. Can we have all of you for a group picture, please? Thank you, everyone. Moving forward, LexTalk is not just a platform meant for networking with the best, but recognizing the best as well. We have the award ceremony scheduled for tomorrow to recognize the individuals and organizations for their contribution to the legal fraternity. However, one of our recipients will not be available tomorrow due to some personal emergencies. Hence, we would like to give you a glimpse of the ceremony by recognizing one amongst us. For this, let me call upon stage Mr. Abhishek Gaurav, the Director of Clickaway Creators Media LLP, to confer the award, please. Let's have a huge round of applause, ladies and gentlemen, for Mr. Abhishek Gaurav. And now the moment, everyone. Please put your hands together and welcome the winner in the category, Leading Managing Partner of the Year in Litigation, ADRs, Real Estate and Corporate Laws. everyone, is Mr. Pranal K. Sunavane, Managing Partner and Standard Counsel at KLS Legal. Please put your hands together for our winner, everyone. A huge round of applause for Mr. Pranal. Congratulations, sir. Can we please have a few words from your end, sir?
Hello, everyone. My name is Pranil Sonavane. I am a managing partner at KLS Legal, basically a litigation and ADR management firm. We are mostly into handling litigations and arbitrations for governments, including central as well as state government, and also for public undertakings. And also we represent many corporate clients, basically in handling litigations and arbitration disputes in Mumbai. We have our branches at Aurangabad, Mumbai, and now we are ongoing to open a branch office in Delhi as well. I thank LexTalk for recognizing our work, and we are really honored. And once again, thank you, sir. Thank you.
I once again congratulate Mr. Pranal, and thank you, Mr. Abhishek Gaurav, for conferring this award. Ladies and gentlemen, now I would like to request you all to disperse for the lunch cum networking break, and we will directly get back after a break of 60 minutes from now. The lunch is at the deck area. I hope you all have a wonderful time and an interesting one-on-one informal networking among yourselves. Thank you. See you after the break. Ladies and gentlemen, the lunch is at the deck area, so please be there.
Hey everyone, Andy Wisher, Chief Product Officer at Agiloft here. Today's the day AI in CLM changes. We're bringing the chat phenomenon to CLM with the launch of Agiloft Convo AI. Convo AI allows users to have a conversation with their contracts using natural
Ladies and gentlemen, we're about to start the next session in 5 minutes, so please be seated. Okay, ladies and gentlemen, welcome back everyone after the lunch. I hope you all are enjoying the conference, gaining some valuable insights, and building connections with fellow experts. So, without any further delay, we will begin with our next panel discussion session on the topic of mitigating force majeure risk in future contracts, proactive strategies for anticipating and addressing unforeseen circumstances. And to discuss this, I would like to welcome on stage the moderator of this panel discussion, Mr. Pathik Arora, General Counsel, Senvian, India. Please, can we have a round of applause for Mr. Pathik Arora, everyone. Our second panelist, Mr. Naveen Kumar Singh, who is the Deputy General Manager, Legal at BCPL. I think he's joining us virtually. Our third panelist, Mr. Amit Kumar, Head Legal and Compliance at Bharat Financial Inclusion Limited. Let's have a huge round of applause for Mr. Amit Kumar. We can cheer a bit louder, everyone. And our fourth panelist, Mr. Chanchal Chaudhary, who is the Managing Partner at Express Legal. Please have a huge round of applause for all our panelists. Now I would request Mr. Pathik Arora, the moderator of the panel discussion, to commence the session.
Oh, Naveen, you're online. So, okay.
Yeah, but
Is Naveen audible to all of you? Naveen, can you speak a bit louder?
yeah. Hello, good afternoon to everyone.
Good afternoon.
Yeah.
Sorry, Naveen, you will not have so much of response considering people may be sleepy after lunch. So you'll have to bear with that. I don't know if you had your lunch or not, but we all had, definitely.
Yeah, I
And
also had.
And it is visible on everybody's face. And I don't know if the lack of more audience is also because we have not yet closed the lunch, or we have started coffee after that. I don't know. Anyways, yeah. So thank you, everyone. I'm glad to be moderating a session which is, I think, post or due, since COVID has taken a different level of, has actually taken a different level. Force majeure was something that pre-COVID, I mean, most of us lawyers perhaps would not even have thought about, or the existence of a clause like this in many of our contracts. And then COVID hit us one day, and as they say कि वक्त बदलता वक्त बदलने में time नहीं लगता. So I think that's how exactly what happened to force majeure. Moment COVID happened, I think since then all of us lawyers will sote jagte force majeure. I mean, that's exactly how it was happening. Seldom people, I mean, hardly people knew what clauses do they have in the contract. Hardly people knew what is there in store for us during COVID. But bus force majeure clause hai ki nahi hai? I mean, that was all that was giving us sleep or sleepless nights during COVID. So those were the times of COVID, I think, which were very, very interesting. And to further the understanding and to take what we all went through during that times, we have our fantastic panel. I think it's a right mix of panelists that we have. Chanchal is the external counsel litigator who advises a lot of banks and BFSIs on on various issues, and I'm sure he would have dealt with many such aspects during COVID, and maybe some litigation may still be on, so, considering the judicial system in the country we have, with no pun intended. And of course, we have Naveen, who would have his say from a public sector side of things, and then Amit from a microfinance or MSME perspective. However, just to set the context, I'm sure we all now know what force majeure is, what force majeure means. I really don't think, I need to really tell you what force majeure is all about. However, the way we have still seen the struggles that we had, especially during COVID, was crazy. We really didn't know what to do. Even if we had a force majeure clause, I'm sure most of our agreements since then did not have epidemic or pandemic as one of the specific inclusions in our contracts. Some contracts said act of God, some contracts didn't say act of God, some contracts were very inclusive, some contracts were extremely exclusive. Hardly any contracts, at least I have seen, who really had a catch-all clause. We had different kinds of contracts, different kinds of clauses in the contracts. To add to it, when COVID hit us, we, all we were busy in were sending notices to each other. I mean, the counterparty has sent you a notice of force majeure, but you're not satisfied. You also want to send a notice back to them. What for? I don't know. But that is exactly what we all did, right? At least I did, or most of us did. And that's how our journey on force majeure evolved. Of course, some departments, some ministries were little proactive, like Ministry of Finance came out with a notification as early as in Feb or March 2020 itself. While it's, while it was seeing disruption in the supply chain, considering lockdown in China happened much before lockdown was even heard in most of the other parts of the country, of the world. Finance Ministry of India came out with a notification being proactive, saying that, any disruption in supply chain because of lockdown or COVID or lockdown in China would be sort of construed as an event beyond the reasonable control of the parties, and thus there should not be any action against the parties who are not able to perform due to that. Taking a cue from that notification, Ministry of New and MNRE, Ministry of New and Renewable Energy, also came out with a notification saying that any projects being impacted because of supply chain disruption in China, and why the focus was purely on disruption in supply chain because of lockdown in China was because, one, lockdown happened in China first. Two, we were still so oblivion from the fact that COVID is going to hit the rest of the world as well, sooner than later. But as I said, some ministries were proactive, and in fact, MNRE also didn't stop there. It also went on and kept on providing extensions of time, for performance, till at least the lockdown was there, until the supply chain was disruptive in India. So that's all. I mean, we have been there, seen all, and that's, and it has become now such an, so it is both ways. I mean, eyesore for some, apple of eye for some, depending upon which side of the table you're sitting on at that point of time. However, the negotiation on force majeure has taken such a turn that these days, while you have a force majeure clause, and which is even, the most robust clause, a catch-all clause, which very clearly says what it has to say in terms of performance is suspended during the times. It even provides you a time period within which if suspension doesn't happen, the event is not resolved, you can even terminate the contract. In spite of all that, these days I have seen people, asking a specific exclusion from performance as a force majeure event mentioned in the contract. I mean, they're so scared of the word force majeure that they don't want to take any chances, come what may. Then came some judgments. I'm sure Chanchal would throw more light on that. It's still a debate whether the Bombay High Court versus Delhi High Court, do they still have a contradictory judgment when it comes to encashment of LC or encashment of BG for that matter, Vedanta case. And I think we are going to have real fun as the jurisprudence evolves around force majeure, so to say. So with this, maybe, to start, I'll rather start with Naveen. Naveen, we would want to understand, what has been the relevance of force majeure clause per se generally in the contracts that you, as PSU and on the infra side, oil and gas side, face in the contracts, and what has really changed since COVID or during COVID and since COVID in terms of how you are viewing those clauses and any changes that you have brought in your contracts or your clauses from that perspective. It would be interesting, hear from you, Naveen.
Yeah. So thanks, Pradeep. And I think you set the context in a very beautiful manner. So as you said about this force majeure clause and all, pre-COVID, people were not giving any emphasis on that particular clause, whether such clause existed in the agreement or not. They were thinking it is some kind of a legal language which in-house legal or lawyer will provide, and we are not concerned about that. Business team. They were thinking that they are not concerned about that particular language. So like a EPC contract, just we said, so normally it is a capital, these type of contracts are capital incentive or long-term contract. So general rule of the contract law is that contract need to be performed, that obligations given under the contract need to be performed. And if there is any, but in the long-term contract, there may be a situation where the party which are unforeseen by the party, that situation may happen. and which makes the performance of contract or obligations under the contract impossible. In that situation, what should be done? So our contract act that we all aware about the section 56 and all, it provides for the termination of the contract in such a event. If suppose that contracts become impossible to perform, then it is a void contract. So it means that it will lead to automatic termination. But in case of a long term and capital extensive contract, parties will not, this termination of contract is not interest of either of the parties. Like a principal or the contractor, even the principal also do not want to terminate the contract. Even the contractor do not also want to terminate the contract. So this force majeure clause is generally exceptions to the general rule. So basically, when it is exception, that this Chanchal will throw more light on that. If it is exception, then it has to be interpreted in a very narrow manner. What the courts are saying that, so in that context, this force majeure clause becomes a very important clause in the long term contract. It should be a well thought and well negotiated clause. So like I was just mentioning about this, pre-COVID, whatever our standard, like I am talking about a PSU like us, we have our standard force majeure clause or general conditions of contract, and contractors were coming and bidding on that particular basis. But today, after the post-COVID, even that in-house team, that business team, our engineering team, as well as the contractor side also, people started looking into that force majeure clause and then seeing that whether that force majeure clause, whatever was provided, suppose that 10 years back in that the standard contract, whether is it still relevant in today's context. So we have changed that our force majeure clause also to suit that current realities and current circumstances. And even this force majeure, now everyone just when you open that this dialogue, so you tell that everyone now started looking into the force majeure. We need to add this, we need to add this. So now this force majeure clause, it is earlier people were saying as a boilerplate clause. Now it is being looked as a tool to mitigate the risk. It is now a risk mitigating. People have earlier also this thing was there, but now its importance has been understood by the people, and we are going in right direction. Hope I made myself clear. Yeah.
Yeah, Naveen, you sure have. Thank you for this. No, I agree with you, and that's exactly I said. COVID hit us, and we did not know what to do, and most of us were like home alone or homebound. So we thought, okay, let's have some fun. Just let's start sending notices to each other. And in fact, we did not even get to the relevance of force majeure to some extent. There were notices. Please, no pun intended. I'm sorry if it is not aimed at anyone. If from an industry that I'm going to talk about are sitting here, but service industries say the contracts which can easily be performed sitting at home, while the work from home was declared, even they started sending force majeure notices saying that it's force majeure, we can't perform. I mean, without really getting into the exact law behind force majeure, which is very clear about, it's not just an event, but an event which is reasonably beyond the level of performance by the parties, which has really restricted parties to perform in a manner they should have performed or would have performed under the contract. There is no way to mitigate, etc., etc. However, I mean, they said, "Wo baad mein dekhenge. We'll see that later. Let us send the notice." Because that's exactly, even the management didn't understand, the board didn't understand. They just said, "Send it." So, of course, I'm sure we all would have taken prudent decisions, like explaining the management what it means and what it should mean and how we should still behave in a particular manner. Because at the end, it was not just one company, one entity, or one region that was affected. The entire globe was affected. And I'm sure people ultimately had to put their head down, sit together, and find a way, because ultimately it was business for everyone. So with this, maybe before I actually go to Chanchal, I would rather finish the in-house part first, Chanchal, because I am scared if I hand over the mic to an external counsel, we may not get it back. So with this, Amit, in your industry, what has been your experience? Uh, as I just spoke about the Bombay High Court versus Delhi High Court judgments, ultimately it all is also about whether encashing an LC could have been stayed because of the force majeure conditions, or encashing a BG could have been stayed, or was it a right or wrong decision? But what has been your experience, with force majeure in your kind of contracts, and what is the change that you have seen pre-COVID, post-COVID, and during COVID? Maybe should help.
Thanks. And the lighter side, I'll say that, from the financial sector, bank and finance, only these entities, financial sector, were not being hit by any COVID, because they were continuously on the service during the COVID period also. So not even a single day leave was there. Not even a single day bank were closed. It was continuing their services. So basically we have two categorizations. If you look at in the banking sectors, we have one documentations with our client and with the service provider. With the client, means the customers, whatever loan we are giving, it's not affecting anyway this force majeure clause, because we have right from very beginning, if you look at these all force majeure clauses, the operations of that, we used to cover it through third party insurance. Like if you have taken the housing loan, you will believe that we used to ask you to give your fire, theft, this burglary kind of insurance. You have to take it. It's a statutory kind of things. Mandatorily you can't take housing loan without that. Similarly, if you have a stock, if you have taken the facilities against this stock, hypothecated stock, need to be covered from this all risk and all. To more further, one more steps that we are taking, credit shield insurance also. That if you have happened to you, like if you have taken SBI loan and all, you will find that they are mandatorily asking you, first you have to protect your property as well as your health also. Even if you have a one health insurance, but they will say, no, the credit shield insurance, you need to take it. So all natural calamities kind of things is being covered under the insurance. So banking, as far as the loan agreements are concerned, it's list affecting kind of things. If you are constructions related aspect, then we say, third party insurance, you have to take it, the constructions related insurance, you have to take it. So they are taking it out, and then we have another terms and condition into that. If you are not furnishing within a stipulated time, then we will of our own, we will take it and we will debit your account kind of thing. So these are the standard in a banking industry, from one bank to another bank, any bank if you will go, these all aspects are covered. Now recently, if you will look at, the RBI has said, if you have a locker also in the bank locker, you need to take your insurance for that. I don't know how the people will take the insurance. I am completely, but RBI has said that, you have to intimate your customer that, locker, whatever you have kept, you have to take your own insurance. Bank is not responsible for that. So if you are not aware of, please go through the terms and condition of the your locker agreement also. You have to take your insurance, because see, the locker, we are keeping out the assets not to disclose anybody, but when you are taking the insurance, you need to disclose to whole world that what are the things you have kept into your locker kind of things. See, the second portion which we are seeing it are the service provider agreements and all. So there the force majeure clause come into the operations, because if our operations are dependent, if we have an IT partner, if we have a service provider channels, if we have a outsourcing agencies for doing the certain activities, so for that we need to have this particular clauses. But during COVID, as because this where the services which was not being held up by any authority, so we were not facing anything, but still we had modified post COVID, that was there, that if anything you are facing it out, incapacity to do particular thing, impossible to do this particular work, then you need to communicate within 3 days or 2 days, so that we will evaluate, our committee will evaluate, we will examine, and then we will come to the final conclusion. So slight modifications has come up kind of things. Hope that's
Yeah. Thanks, Amit. Would you want to touch now or later, Amit? Maybe in case you want to touch upon the BGLCs later, maybe next. Yeah, sure. That's fine. No, that's fine. You can. I hope we'll have time. Let's see. Yeah. So with this, maybe I would straight away bring in Chanchal from a litigator or external counsel perspective, and maybe it will be interesting to hear anecdotes from you on how have you seen this journey? I mean, how have your experience been with the FM clauses pre-COVID or when COVID was not even heard of, so to say, and then suddenly so much of focus on the FM clauses, and we have seen so many disputes only on FM clauses, in the courts on various aspects and across industry. It has been sort of industry agnostic when it comes to disputes. So would be interesting to hear you on on that journey, maybe.
My pleasure. Two things we need to understand in terms of the force majeure clause. One is that the force majeure clause is not new. See, the Contact Act was enacted way back in 1872. Even in Contact Act 1872, there were the provisions of Section 56, which talks about the frustration of contact. We all have been students of law and we all have gone through this provision. What is the frustration of contact and impossibility of the contact? So those were there. I am the one who was the general counsel and turned advocate as an external counsel. So I have been to both sides of the table. And even in 90s, when I was a general counsel for the corporate, we always used to have a clause of a force majeure. Yes, as for the scope of the force majeure clause, post-pandemic, it had changed to the extent that lot many words, those were not included before pandemic, have started getting included in the force majeure. Something like, the pandemic, epidemic, lockdown, quarantine. Now, when we make an agreement for our clients, we try to cover all these words in the agreement itself, in the force majeure, understanding that if the pandemic has come today, tomorrow is no guarantee that it won't come back again. In order to, leave behind any kind of a speculation and interpretation, we try to cover this clause in the force majeure clause. Earlier, if we talk about the force majeure, it was more regarding act of God, Also something like flood, something like earthquake. These were the words, those have been used in the force majeure clause. And that was the, the kind of the mindset or kind of the provision which we had in the Contact Act 1872. So that force majeure was there since 1872. Is not something new that has come out only after the pandemic. Before pandemic, before lockdown, before COVID, the force majeure were there. All the advocates normally used to advise all the clients to have that clause. But yes, the provision of the force majeure that has changed, that has enlarged, that has been widened in order to protect the right and the interests of the client for whom we are preparing the agreement. Now, we also need to understand what is the force majeure. Force majeure, understand that neither party will be liable for any failure or delay in performing an obligation under this agreement, that is any of the following causes: that beyond the reasonable control, that is act of God, as I was talking, that was the one which was well before there, even this pandemic. So act of God, accident, riots, war, terrorist act. Now I'm using certain new words that has been added only after the pandemic that we have seen in sometime in 2000 and again in 2021. That is epidemic, pandemic, quarantine, breakdown of communication, breakdown of web hosts, breakdown of internet services providers, government act or omission, changes in law and regulations, strikes, fire,
generalized lockdown, inavailability of the raw material or energy. See, these are the words that has been added post-pandemic, and it was needed because lot many contact that has come before the court to understand whether this part of the contact comes under the force measure or not. One of the experience that I want to share with all the audience, I happen to close an agreement for one of my clients who are into the catering and decorations. They were doing the catering decoration. Mumbai, as you understand, a lot of banquet halls are there for a lot of events that is to be organized and a high value contact. So I drafted a contact. As usual, before pandemic, the situation was hardly 2 line to be added as a force measure. So we put all this force measure clause in the agreement. But because of the pandemic, he was unable to perform any kind of the event in the banquet hall. And it was continued almost a year. Reason is being that though the pandemic was lifted or the restrictions were lifted, but yet certain type of restrictions were continued for almost a year. Like you can't invite more than 50 from the groom side or from the bride side. Now a caterer who is paying a high value rent for the premises, who has given 10, 20 crores of deposit for that kind of premises, if he is restricted to invite the 50 guests or the 100 guests, imagine his situation, that how he would be able to meet even the expenses that is otherwise required to maintain such kind of the premises. The property was owned by a trust. I'm just sharing a live example that I have gone through in respect of the force measure. So our client has spoken to the trustees of the trust and said, sir, this is the reason, and therefore we have not paid for the 1 year or the 6 months time that he has not paid. And that needed to be excluded because it was a kind of the force measure situation, because we were unable to perform any kind of the function. And since we have not collected any revenue, any money from the parties, from where will we pay you the rent? As usual, the trustees were not agreeing to that and was insisting that whether you were able to perform or not, because the rent was decided on a monthly basis, not on the function basis. So whether you were able to conduct the function or not, whether you were able to invite 50 guests or 500 guests, we have nothing to do it. There is a fixed rent and that you are required to pay every month. And if you have not paid, the contract is subject to termination from the trust side. A lot of negotiations has happened. In fact, our client was also insisting the contact period needed to be enhanced, the 6-month period, that he couldn't made use of the particular hall, the banquet hall. So the contact period, if it is ending in the June and the 6-month period he has not used, so it should end in the December. So 6 months should be extended because that is the period of the time that he has not used. The trustees were not able to do that. Finally, we had no other option but to move to the civil court there in Mumbai, like Dindosi court that we have over there as a district court. And the matter was argued heavily before the court. And finally, the honorable judges have passed an order in favor of our client and have allowed him to continue for the 6 months. Deposit remained in the custody of the trustees. The rent, of course, he was required to pay for the 6-month period that was extended. But then, it's all left on the interpretation of the pandemic clause or the force measure clause, because those words were not added at that point of time, because nobody has envisaged the situation that a time will come when we'll be restricted to move out from our own house. So those restrictions have come. The lot of, because of the lockdown, lot of restrictions have come from the police, from the local authorities, and the business were almost come as at halt, and the people were unable to earn anything. So those were the situations that needed to be dealt with. So post-pandemic, what is required now, that we need to be more clear and try to cover all the words that we have already faced into, and maybe add something that is yet to come, and we never know as and when we require to face it. So as an advocate, as a lawyer, we need to be little futuristic kind of the situation that the client may face in a given time, and we need to cover up in the force measure clauses, by virtue of which, even if situation arises like it has happened in 2020 or 21, or maybe worse than that, the interests of the client remain protected and the client is not required to pay for the period for which he has not been using the premises, or the contract has become frustrated because of the enforceability. Now, these two provisions, if I remember, Section 32 of the Contract Act and Section 56 of the Contract Act 1872, these are the two provisions of the Contract Act is very necessary. So while drafting any kind of the contract, whether it is a technology contract or the rest of the other contract, we need to be, even for the matter of the home loan or the project finance loan, or for the rest of the project loan kind of the things that the bankers does, we need to be little careful about it, and we need to cover it up so much so that if a time comes, we are able to protect our own rights because of the impossibility of the contract or because of the frustration of the contract.
Sure, thanks, Chanchal. I mean, this has been, of course, quite food for thought for us in-house councils, on how an external council would have looked at it or looks at it. And I agree, as while, of course, Section 56 has been in operation since long, and Act of God, so to say, has been. But then again, there also has been a debate about whether pandemic would automatically fall, under the Act of God or not. Supreme Court of India, while has not really, in many judgments, have not really come out saying whether pandemic is an act of God, it's not an act of God. However, the inference from those judgments, of course, has been that more often than not, pandemic.
Something like Aloki Prasad and Sons Limited versus Union of India. These are the 2-3 judgment is a landmark judgment in respect of dealing with the force majeure clauses. Something that I can quote before you guys is Energy Watchdog versus CERC, Satyabrata Ghosh versus Munir Rahman Bangur and Company, and Alopi Prasad Sons Limited versus Union of India. These are the cases where the Supreme Court has dealt the matter in detail and have narrated as how the force majeure clause should be read and should be enforced in order to protect the interests of both the parties of the agreement.
No, I agree. And that's what I meant. Of course, they've gone in detail, dealt with the matters, but today, correct me if I'm wrong, but in my view, today also there's no real rule of law which says that any pandemic would automatically get into the Act of God, whereas the Supreme Courts of US and UK have actually long back gone ahead and said, in various judgments, including in flus, which have been epidemics or pandemics, where they have really categorically stated that pandemics should be treated as act of God in judgments. So exactly. So I think we also need to be little jurisprudence also still need to evolve. I don't know for how long will we remain a developing nation, but that's how. But having said that, any anecdotes, anything that you would want to say, Naveen? Sorry, we have kept you silent for a long time.
So basically, that whenever the force majeure situations occur, so I saw that two kind of situation. One, suppose a party try to take advantage of that particular situation. Suppose he do not want to perform that contract, but under the garb of that force majeure situation, he'll say, no, now force majeure situation has occurred, and that's I'm not able to perform, and it should be suspended. And the second category will be where the genuine impossibility to perform the contract is there. So while looking into whether it is falling under the force majeure situation or not, we need to see whether it is difficult for a party to perform the contract or it is impossible for the party to perform the contract. If it is difficult, then it is not falling under. So like I just quote an example, that real example. We had a refinery in our Kochi, that is in Kerala, and that EPC contract was given to a contractor for a period of one. That contract need to be performed this thing within a period of 12 months, and the contractor, there was some delay on the part of the contractor, but during that monsoon period, because the force majeure clause said that flood, so he issued a notice saying that no, this is a heavy rain is there, and due to the heavy rain, now it is a force majeure situation, and I'm not able to perform that contract, and here there's a force majeure notice. So there we responded to that, because that this in Kerala, that in monsoon period, by at the time of entering in that particular agreement, everyone is aware that in Kerala and that or in Mumbai itself, at the time of monsoon, heavy rain will be there. So while quoting for that particular tender, all these thing parties are aware what need to be taken in that. So heavy rain cannot be termed as a force majeure situation. So those kind of things are there. Like Amit was also telling in the technological front. So suppose during the quarantine period and all, if you are able to perform that your work at that sitting at home, you cannot say that it is a force majeure situation. But that force majeure situation may be for some other kind of contractors. Like our company also, because it is essential commodities, we need to maintain our supply chain. All retail outlets, LPG distributorship, everything has to be open. So my contractor cannot say, no, look, it is a force majeure situation, I will not come and work. Whereas the company need to perform those things. So we need to see at a case-to-case basis. Fundamental thing is whether it is that particular event is making the contract difficult or impossible to perform.
No, I agree, Naveen, and I completely agree. There is no one size fits all approach that you can really apply here. It will depend upon facts of the matter. It will always vary case to case, and of course, force majeure. The fundamental of force majeure is it's not just an event, but it has to really push you back on performance. I mean, there is no reasonable way for a party to perform, and there is no other way to mitigate that non-performance. Is when force majeure generally should kick in. And I also agree with you, the same example, oil and gas or energy sector. I mean, one was COVID, other one was lockdown. And, the consideration also had to be given whether the force majeure per se is COVID as a situation or the lockdown that is emanated from or because of this. Because, even with the energy sector, you had to maintain, it was an essential service, right? So you have to really keep operating that. But now, how do you operate it if you don't have a means by way of any public transport for your employees to even reach remote sites where maybe, your solar parks or your wind parks are installed or are operating? So it was definite, I would not maybe use the word like a lack of thought, but definite lack of real understanding as a concept on what should be force majeure, what should not be force majeure, and how one needs to read a clause.
So Pratik, I just want to add here, because this mitigation, the discussion among the party to mitigate that effect is very much important when these force majeure situations happen. Like the example what you said, like suppose a lockdown is there and that worker cannot reach to your this particular plant and all, then what in that particular situation you cannot blame that contractor or that this thing. So for that purpose, because that then like in our industry, there were concession was given by the government of India that these plants can open, this vehicle can move and all. So those kind of this thing is provided. Suppose had those kind of provisions and concession was not there, obviously the other party will say, I am unable to do this thing. So that mitigation measure, communication between the parties to see the interest of both the parties. You cannot look at your own interest. You need to see that interest of other parties also. And where the dialogue and everything is clear, this resolution will be, you can arrive at that particular resolution. When both parties are looking at their interest only, then matter will go to the court and honorable judge will decide what to be done. Yeah.
Sure. Yeah, appreciate Naveen. Amit, you have been trying to say something.
Agree with the Naveenji's view. See, the essential services were allowed and concessions were given to move and all, including the banking also. Though we agree with the Supreme Court has not very clear on this particular aspect, but the benefit of doubts were given to the customers as well as the vendors and all. Because if you look at from the banking perspective, Supreme Court keep on extending this particular NPA. The bank cannot declare NPA because that all period has just excluded. Even no actions can be taken during the COVID period and all. So that also was continuing for a longer time. Though they were not clear, but still RBI was keep on asking, regularize the account. So in between, the intermediary kind of circular we used to being given to the banking and financial sectors, to cater kind of things, they were not been given the repayment kind of things. There were some.
Invariably said, it is a human face. It is not purely precisely the law requirement, but there were some sort of the human face, even the judges or the courts also has, because they have understood the kind of the situation that everybody was facing through. The salary were cut, the people who are not getting the salary, and those salaried people, defaulted in making the payment of the EMIs. Those periods have been excluded, and they have been given the relief.
Keep on extending kind of things till the last limitations. You have during that period, limitations is not being bad kind of things. You can have from that date and onwards, limitations will continue. Account can't be declared as an NPA. So lot of
court while analyzing these facts, the court has said the hardship is not the remedy or for the reason for the invocation of the impossibility. Are you getting me?
True.
You might be facing the hardship, but what you need to prove before this court is the impossibility, that it was impossible to perform. Merely saying we had the difficulty, we had the hardship, we had the loss, we had the profit, we had the less revenue, we had the more revenue. I mean, those cannot be the reason for implementing or for the as per the invoking the force majeure clauses.
And
the
beyond
force majeure clauses is for the impossibility. Was that the situation in which it was made impossible for you to perform? If the answer is yes, of course the force majeure come into play. If the answer is no, it was merely a hardship or difficulty, no force majeure could be implemented in such situation, because then it becomes very difficult for the parties to perform or to fulfill the obligation that is written under the agreement itself.
Yeah, but still, of course, some standard provisions were or standard benefits like moratoriums. Moratoriums was one.
Restructuring of the accounts.
Restructuring of accounts. So this was one. Yeah. So
specifically on the bank guarantee, what has happened? They have not given, because they said that bank guarantee is a separate contract and how it is affecting kind of thing. So they have not given the relief just because of the bank guarantee is a separate contract. They have Supreme Court was of the view.
The law is also evolving to that.
Absolutely.
You need to understand the law is not framed. Court has also the first time faced such situation.
True.
Where in such situation the parties were coming before them. So law is not clear. There is no past order of the judgment to that
precedent
so
to that.
it was, kind of the evolvement of the law in a situation in which how the court should.
No, completely agree. I mean, while businesses would have suffered,
yeah,
lawyers definitely gained a lot on terms of knowledge from from an episode like this. So maybe quickly. Sorry, Chanchal, you want to say anything more? Or no? I was just opening this before we make our concluding statements. Maybe any questions? Yes, sir.
It's not a question, see, what happens is, if you look at it, Supreme Court invoked Article 142 and extended certain time limit from the, what do you call, time barring.
Time clause, yeah.
Time barring. And also introduced another section called 10 capital A in the IBC, saying that during that time, if you have declared an account as an NPA, if you go and file a section 7 or 9 or application, that is not valid. So, and subsequently what happens is, the Supreme Court or none of the courts or never said that it's only a deferring of the payment. It is only a deferring of your contractual obligations. It never said you can write it off.
They've never been exempted from the
write it off
performance.
is not written at all. So as somebody said there, is that in 2018 in Kerala, there was a heavy rain and landfall and everything. But that is a state subject and, see, whatever happens, for a pandemic, it has to be declared as a pandemic, which has to say that, you are unable to perform certain things. And in Bombay and all, what we did was that, we renegotiated many contracts, renegotiated and, made the rentals payable to half or 25% and something like that. So ultimately, the short question is that even if I write in a contract that it is a pandemic, pandemic will come as a force majeure. It is not that I can say that, there was a COVID and, now in 2024, if we write pandemic and if a COVID resurfaces, I don't think we will have the same effect as it was in 2020 because, nobody now bothers about COVID, because it's all over. And that is the reason. So what is done was only a deferring of the payment. It never gave any blanket exemption to say that you don't have to perform your contract. That's
No,
what
that
I
is
think.
true, but this is exactly what force majeure anyway is all about, right? Suspend the services where services are capable of being suspended but can be taken over. However, if like section 56, if something has
Yes.
happened which has just frustrated the
No,
contract, I
either
mean,
you
there's
can
no
terminate the contract
exactly,
or, you
then,
can, so you give some
and
6
that is
months
why
time,
normally
etc.
you keep a suspension and termination both rights in a
Both
contract under
rights.
force
So
majeure
pandemic
events.
as such, even if we write, is subject to what the court says. The court has to say whether it's something which was incapable, which prevented me from fulfilling my contract, and as a result, so
No,
yes,
precisely if we talk about the section 56, the frustration, it make the agreement itself as a void. Are you getting me? If that clause come into effect, section 56, if we talk about the impossibility of the contract, the frustration of the contract itself become void. Neither party can be held accountable, responsible for the non-performance of their obligation under that contract. So 56 talks about the not voidable, the complete void of the agreement, because you have entered into something which cannot be performed by the other party, by one of the party or by both the parties. In such situation, agreement itself becomes the void and unenforceable. It can't be enforced.
that is again, for the pandemic, it has to be decided by the court. Essential services were there. The manufacturing activity was not stopped. We were getting food. We were getting all kinds of Maggie and everything. Biscuits and everything was manufactured. Medicines were there, and ultimately, second thing is banking service was in full swing, and therefore, I think it's left to the court to decide. But we can still write.
Sure.
That. I don't want to.
So as you can see, intentionally, we have not left any time for Q&A, but in case there is any still one question, we can still take, time permitting. Okay, so I'm glad. So thank you so much. I think it was, the topic is such that we definitely can go on and on. It's so fresh in our minds right now. And maybe some of us, sorry, but maybe some external counsel are still waiting for some other pandemic to happen because I... Exactly. We even went to the extent of debating, whether lease, I mean, we had a whole long debate of lease versus license and whether it is a force majeure or whether, we should stop paying rent or a license fee in force majeure or not, and how lease is different from license and so on and so forth. But with this, I think, thank you so much. Thankfully, I didn't see many sleeping faces while we were right after lunch. So I assume, and as lawyers definitely do pat their back, I assume we did a good job. Thank you so much. And thank you so much for being part of the audience. Thank you.
Thank you.
After post-lunch.
Thank you, gentlemen, for putting up such an interesting and a great session. A huge round of applause for all our panelists. Can we have a group photograph, sir, please? And thank you, Mr. Naveen Kumar Singh, for joining us virtually, sir.
Thanks.
Now, to continue further this journey, we have few panel discussion and case study presentations lined up for you. So with a huge round of applause, I would like to invite upon the stage Mr. Amrinder Singh, Senior Director at Virtuous, for a case study presentation, who will be speaking on the topic of no-code digital contract transformation using AG Loft. Please welcome, sir, with a huge round of applause, everyone.
Is it working now?
Yes, sir.
Thank you
Over
for
to
the
you, sir.
introduction.
Thank you.
Good evening, everyone. I am Amrinder Singh, Senior Director at Virtuous Digital Limited. I'm into CX and digital transformation division of Virtuous. We are representing Agiloft here. Can you start the presentation, please? Yep. So we are representing Agiloft here. Agiloft is a US based. This is forward. Forward, backwards. Yeah, thank you. We're representing Agiloft, which is a US based contract lifecycle management solution, a leader in Gartner. And we are representing them in India. We are an extended arm of theirs in India. We are talking about how Agiloft is fundamentally different from other contract lifecycle management tools. It was interesting, the elite panelists, they were discussing about the situations like force majeure and pandemic. And that also increased the utilization of CLM tools like Agiloft in the last 5 years, because large organizations felt the need to understand and make sure that these kind of events are not gone unnoticed and are well taken care of. We'll talk about those also during the presentation. What CLM can address? The CLM can address for you the centralization of repository of your contracts. We see that even today, there are a lot of organizations who are not using any centralized repository, and they get into trouble while discussing about the contracts. They find it very difficult to find that there is a specific term in the contract also which they needed to be compliant to, and they are not able to. And consequently, then it causes them losses, because the compliance, when you are not compliant, the other company can sue you. Second one is the visibility of workflow. In large organizations, it is difficult to also find out, when there are several contracts in place, who is going to sign what kind of contract. With the tools like Agiloft, we can ensure that everyone is able to see who is going to approve and when that approval will be done. So there will be turnaround time, there will be SLAs also associated with that process. Third one is, when you are not sure who is going to approve, when you urgently need certain contracts to be signed, you will have the visibility to see that a certain person in the hierarchy is the one where the contract is pending, and then you can nudge them through the system itself that we need this to be quickly signed. The most pressing issue is the templates. You will see that different departments in your organization, whether it is sales, legal, procurement, they will use their own templates. They will, and those templates may or may not have certain mandatory clauses. And that increases the back and forth communication, approvals, rejections, and in turn, it increases the time taken to sign the contract also. And due to these delays, sometimes you may even fail to sign the contract and may even lose the deal. Standard clauses. Every organization needs to have or wants to have certain clauses library with themselves, so that whenever you are creating a contract, that contract has all those terms and conditions by default. And if you need to remove anything due to any exception required, you can do that. But the default clauses should always be there. You can utilize them, and you can change them based on your custom requirements as well. And there can be versioning of those. And fallbacks. Most of the times you will find that there are different companies who come back and say, this is the clause we don't agree to. Then do you have any fallback clause also available? So the system will be able to address that. For certain clause, you can have these two types of fallback clauses also included. Why Agiloft? Why are we representing Agiloft? So what we do is we normally go to third-party reviewers and then get the review done through them to identify who are the leaders in contract lifecycle management. If you see here, we have Gartner, Forrester, and IDC. All of these are leaders in reviewing. Most of the customers, when they look for contract lifecycle management tools, they approach them and they ask them, please suggest us which solution we should go for. And we are there right at the top in the leaders quadrant. In addition, we go to G2 Cloud also, wherein customers also give reference about us. And if you see implementation wise, 97%, and support wise, Agilloft has 92% satisfaction, wherein the average is 70 to 80%. So while a lot of companies are not using CLM today, but in next 5 years, most of them will be utilizing CLM. As I said in the previous slide, they go to Gartner, Forrester, etc. We are right at the top, and we can help organizations improve their contract lifecycle management. What does our data show? We don't only rely on the data shown by the reviewers, but we also compare by going to our customers and then checking these statements with them. How are we performing? What kind of efficiencies which we have brought in? So compliance wise, the factor of 3x operational efficiency, security wise, 2x operational efficiency, and in purchasing, the leakage of revenue, we have that saving of 12% there also. We know that not all of the organizations go full throttle to implement CLM from day one, but they can start small as well. As and when their maturity level of using contract lifecycle management tool solutions increases, the ROI which is returned to them, which they get, also increases. The very first problem, as I said, accessibility. Where are my contracts? We have seen in the past that companies used to come back to us and saying, Amrinder, share the contract which we had signed last year. We gave them the CLM. Now they don't approach us because they know all their contracts which they have signed, they are at one single place, and not just with us, for all their customers. Normally this problem arises when you have hundreds or thousands of contracts and you have multiple people managing them, and they are utilizing possibly Outlook, Google Drive to maintain those contracts. And when some of the employee leaves the organization, the access to that contract also goes with that. Second most important, key term, the next level of maturity is, after having access to all the contracts, you may also want to find out what are the key terms which are very important, which can cause losses or can bring, you can say, more revenue to me. Whether there are people who are compliant, the other contractors, are they compliant to these terms or not, right? We will find that several times later on we realize, after re-signing the contract or renewing the contract, that a certain vendor had breached certain clauses and we did not notice. If we provide the data to the system will be able to notify that to you that this particular term is getting breached. And you will be able to identify, you may want to penalize or caution them not to do that in future. Third level of maturity is you want to author the contracts also using the solution, wherein automatic approvals or rejections based on the AI capability of the system, or certain standard procedures which you have defined in the system can be done. That reduces your operational time and cost in signing the contracts. Once you achieve this level of maturity, then you think of, okay, there are people who are using Microsoft, they are using Salesforce. Can my sales team also directly create contracts requests within the system? you can integrate with those solutions as well, and you reach that level. And finally, optimization. Now this optimization, though reaching the fourth level, you have reached an optimization, the optimum level already, but with the help of AI and Gen AI in Agiloft, you can further optimize things. At the end of this presentation, I would request to showcase a video here that will be showcasing a very basic functionality of how AI can help you. That is one of the many capabilities of Agiloft. And if you want to see that in detail and you want to discuss and have a demo, you can go to our stall number 4, which is very strategically placed right next to the restroom. These are certain pain areas. We have already discussed a few. But if you see different departments, all of them have few pain areas when it comes to contracts. Legal will say they don't have control, they waste a lot of time. Sales will say that legal team is taking a lot of time in review. Finance will say that we don't have transparency. IT will say that I don't have ample resources to take care of your contract management. And Agiloft can take care of all of them, all the problems at once. Now coming to why do we say we are fundamentally different? Our tagline is we flex, extend, and integrate like no one else. When we say flex, we are a born BPM solution, business process management solution. That means we are a low code and no code solution wherein you don't need technical people to configure the workflows for you. People who have basic understanding of using tools, like you are using Instagram, you are using Facebook. Likewise, this can be another tool which you can use to configure the workflows. And mind you, we are not scared of any complexity in your business processes because we can implement it without coding. That is the beauty of the tool. That's why we say we flex. Extend. So you want that data, since we are a cloud-based solution, though we can be an on-premise, as in on your own data center also we can be there. We can extend the solution to any other solution as well. We can integrate with others as well. Okay. And if your requirement, as it is written, square peg to a square hole. Most of the times we find that the businesses, the requirement is X and the implementation is X minus 2. But our solution, with the current solution, we can give you X plus 2 as well. Integrate. Most of the CLM solutions which we see in the market today, they are siloed. They find it very difficult to integrate with other solutions. In the next slide, I will talk about what are the capabilities of Agiloft in integration. The first panel talks about native integrations. You will see that most of these tools which are native here, you might already be using those. Outlook, MS Word, Microsoft Teams, Power BI, Salesforce, Tableau, Adobe Sign for digital signatures, or eSigner for that matter. Those are natively integrated in the solution and we don't need to put any effort. The only thing which we need to do is configure the account of those solutions within Agiloft and Agiloft authentication in those solutions, map it, and then it starts working for you. In 2022, we launched Integration Hub, wherein more than 400 solutions are listed as the integrated solutions to us. And apart from that, if your solution which you are using it is not listed, we have third option, which is the iPaaS connectors. These are integrated platform as a service connectors, Dell Boomi, Workato, MuleSoft. If they don't have it, we have open APIs also available through which we can integrate with any solution of your choice. You'll find that there are a lot of CLM tools who cover few of these, but then we cover the entire life cycle journey of the contracts life cycle management, whether it is contract request, reviewing, negotiating, approval, e-signature, and finally analysis on those as well. Which are the most profitable contracts I have? Is there any contract which has red lines? All those details will be available to you through the analysis. Works across all your business processes, whether it is finance, procurement, legal, sales, and their sub processes and requirements, they are all covered. As we were talking about the maturity level, whichever maturity level you are at, we can still help you. Whether you are still aggregating your contracts, or you are in the process of automating, or you want to integrate, or you want to optimize using the AI and analytics functionality. In the second last quarter of 2023, in Forrester Wave, we were listed as the leader, which is the top right corner of the quadrant. It has around 17 criteria, which includes contract lifecycle management, workflow, dashboard, reports, and everywhere we are the standout performers. These are few of our customers out of 700 global customers we have. Most of our Fortune 200, most of the Fortune 200 companies are using Agiloft. Now I'll move on to certain case studies. The very first one is JB Hunt's, which is a transportation and logistics company in US. Their challenges were hundreds and thousands of documents, more than 25,000 contracts. They wanted to have, they had used 3 CLM tools already, but they all failed. So they were, you can say, once bitten, twice shy customer. And still we were able to win them because we, even after they evaluated 20 more CLM vendors, we were the ones who they identified that they can take care of their requirements. We integrated with Microsoft Dynamics. We enhanced the efficiencies across purchasing, CRM, and contract lifecycle. And now the result is that they can now capture detailed metadata to identify and optimize the processes and other part of businesses. They have reliable forecasting for resource for agreements and improve contract visibility and accountability. Second is Jade Global, which is an IT services and consulting company. Their revenue is 219 million in 2024. Their requirement again was to automate contract execution. This requirement was slightly different. This was related to sales contracting. and their requirement related to SLAs and TAT was immense, very important. They wanted the contracts to be signed very quickly. That means they needed the reduction in time taken to execute contracts. They were using existing solution Salesforce. Their salespeople had the challenge that they were not having visibility into what is happening to their contract requests. So we integrated with Salesforce. The current status and the complete life cycle update was visible to the salespeople within Salesforce when they raise the request. And the efficiencies were going beyond the initial process. There were reminders to sales requests regarding necessary follow-ups, and they were all done automatically, not manually. So the effort from the sales people was to bring more business rather than following up with the contract teams, the legal team. Now they have automated workflows and notifications. They have reliable forecasting of resources for agreements. They have improved contract visibility and accountability, and increased transparency and harmony across sales and legal team. Finally, there is Amerisure, which is a commercial insurance company. If you see these three case studies, I have given you different verticals. That means it can take care of the requirements of all types of companies. They wanted one source of truth for and during and after negotiation. They also wanted immediate accessibility to contract terms and ability to measure performance of contract terms throughout contract lifecycle. With the solution, they were able to improve compliance. Earlier, it was a lot less. Now it became 90%. The time wastage which was required which was done by the legal team in the entire process was reduced, and they were able to quickly transfer knowledge from Agiloft team to internal resources. Though I have introduced ourselves already, but then again, we are the extended arm of Agiloft in India. We are their partner in sales and implementation of Agiloft, and we have more than 250 projects and more than 100 customers in India. Thank you very much, everyone. I would request the team to showcase the video as well.
Hey everyone, I'm the Chief Product Officer at Agile here. Today is the day AI and CLM changes.
Thank you.
Common AI allows users to have a conversation.
Thank you, sir, for putting up this wonderful session amongst all of us. I would like to take this opportunity to thank Virtuous for their support as a diamond sponsor. So please have a huge round of applause for Mr. Amrinder Singh, everyone. Ladies and gentlemen, now let's take a quick 30-minute tea break before our eyelids starts competing with gravity. And trust me, caffeine is the best defense against the snooze button. So see you after a half an hour break, everyone. Thank you. Ladies and gentlemen, we'll start the roundtable discussion in 5 more minutes. So please join everyone after 5 minutes of tea break. I request everyone to please be seated for our next roundtable discussion. Welcome back, ladies and gentlemen. It's time for our roundtable discussion, the last session for this day one of the LexTalk World Global Conference, which is on the topic of enhancing cross-border dispute resolution in the Commonwealth, exploring effective mechanisms for resolving legal disputes across jurisdictions. And to speak on this topic, I would like to welcome on stage Ms. Smita Chandrasekhar, Director Legal at Harman International India Private Limited. Please have a huge round of applause, ladies and gentlemen. Next is Ms. Astha Chawla, Director at American Arbitration Association, ICDR Asia CMC. Please have a huge round of applause for Ms. Astha Chawla, ladies and gentlemen. Next is Mr. Balakrishna Gopalakrishnan, founder at BGK Law Associates, Advocates and Legal Services. Welcome again, sir. Unfortunately, Mr. Kanishk, Director Legal Uber India and South Asia, and Mr. Abdul Rahim Padanhares, Senior Legal Manager at Cars 24 Arabia, couldn't join us today. Further, Dr. G.V. Rao, Senior Advocate, Supreme Court of India, Vice President of the Indian Society of International Law, is on his way and would be joining us very soon. So I would request all the other people to start their the roundtable discussion. Thank you.
Thank you. So, good afternoon, everybody. I hope you're all refreshed after the chai break. Since the panel is like really small, we'll try and keep it as shorter and as crispier as possible, right? So, with that, let's kickstart the session. I'd like to request my co-panelists to give a real quick introduction about themselves, please.
Thank you, Smita. Thank you very much. I'm Astha. I'm the Director Asia of American Arbitration Association, International Center for Dispute Resolution in Singapore. As a part of the institution, my duties involve case management from across Asia and also business development for the institution across Asia. I'm very happy to be here and on this panel. Thank you very much.
I think in the morning I have introduced myself, but I'll add some more things. I'm Gopal Balkrishna, and I run a law firm called BGK Law Associates. And formerly I was heading the law department of Axis Bank, and I was working with the RCIL also, Asset Reconstruction Company. And after that, you find somewhere here, a small emblem called CCAI. That's a Corporate Counsel Association of India. It's a gathering of in-house counsels, and I happen to be the founder president of that. And I'm also a guest lecturer in many of the law colleges, and I'm in the board of studies of some private universities in with regard to law. That's it. Thank you.
Thank you so much. And I'm Smita, and I'm the legal director for Harman, and been around in the field for 2 decades now. Feel so old, right? With that, let me just quickly start the actual session. So, in terms of quick statistics, before I proceed, Mr. G.V. Rao is here, so welcome. Perfectly on time then. So this, I'm happy, that at least a senior person is here, and, we will definitely be benefited by his words of wisdom, right? So with that, quick statistics, in terms of numbers, um, I was just taking a look at the cases disposed of by SIAC and Hong Kong International Arbitration Center. And in the year 2023, there were at least about 300 plus cases which were actually settled by these arbitration centers, right? So that's that. And arbitration, mediation, conciliation, things like these, I mean, the whole dispute resolution mechanism, right? I mean, it's a pretty old concept, if I may say so, because WTO, World Trade Organization, in fact, started disposing of or hearing matters way back in the year 1995. And apparently till now, again, out of the 600 odd cases which were filed before them, about 300 plus cases saw the light of the day, and it was like very wonderful sorted, right? So dispute resolution mechanism, especially for cross-border disputes, has definitely gained momentum over a period of time, right? So with that, quick introduction. Astha, I'd like to ask you the first question. So you are from a dispute resolution institution, right? So coming from this particular institution, what's the recent trend that you've actually noticed in the dispute resolution arena, especially in the APAC region, because you are based in Singapore, right? So that's the first part. Second part, are there any challenges that you have been noticing as an institution? If yes, what is it that your institution has actually done to kind of deal with those challenges? So I think this will be very important for the audience to understand from a practical perspective, since you are the institution, you're representing an institution. Over to you.
Thank you very much, Smita. Thank you for the very topical question that we are dealing with these days. And before I answer the question, I understand that you have mentioned the caseload of cases settled by SIAC and the Hong Kong Center, HKIC. I would also like to add on that AAA, American Arbitration Association, in 2024, starting from 1st of January, has resolved 95,719 cases. So it is just in first 1.5 months that we have resolved around 1 lakh cases. And since 1926, we have administered around 8 million cases. So that's the caseload that we have. However, having said that, Singapore, SIAC and HKIC, most of their caseload is international arbitrations. With AAA, we are both domestic and international institution. Our domestic caseload is very high. Around per year, we administer 500,000 cases. As far as our international caseload is concerned, which is held by ICDR, ICDR is another segment of AAA, which handles only international cases, and caseload for international cases is around 800 to 1,000 cases every year. So before, I just wanted to mention that and introduce probably our institution, probably the recognition it deserves, and probably justify my salary. So now coming to the questions that you've asked, recent trends. We all have read the recent judgment on Amazon versus Future Retail, where an emergency award was passed and it was then taken to court, where the question of law was whether Indian law recognizes emergency awards or not, and whether such an emergency award is a final award or not, and can it be enforced in India or not. So these questions were addressed by the Supreme Court, and it was held that these emergency awards are an internationally recognized concept and must be enforced. This happened in 2022, later, end of 2022 and beginning of 2023. There were appeals as well. So although emergency arbitration was introduced by American Arbitration Association back in 2006, however, the trend of emergency arbitration has become popular in Asian region only in the last 1 decade. And in India, it's still picking up. And thankfully, we have Amazon versus Future Retail, because of which now Indian parties are not hesitant, and even foreign parties are not hesitant in applying for an emergency award, and since they know that it can be now enforced in India, because an award is nothing unless it's enforced. So that is one recent trend that we are seeing in India. The other recent trend that also is very close to my heart is mediation. Mediation has been picking up. Singapore passed its mediation convention recently, and there are certain countries who have now ratified to the convention. But in our rules, in AAA ICDR rules, earlier before 2021, the concept was when two parties have arbitration with ICDR, they can opt in for mediation. In case they want to mediate, they can write to ICDR that we want to mediate separately. Is it okay that we go ahead with mediation? And that was an opt-in clause. However, we amended our rules in 2021 to promote mediation, and now the parties have to opt out of mediation, which means that if the parties are going for an ICDR arbitration, it is presumed that they will go for mediation as well. Now this might come across that it is a tactic for delay. So to cater to that issue, what we did is that the arbitration and the mediation will go parallelly. The timelines of the arbitration will not stop because of the mediation, so that no party can use mediation as an excuse to delay a case. If both the parties agree that the arbitration timelines must be stopped, then we, of course, because arbitration is completely party-driven process, in that case, we stop the timelines of arbitration. But if there is a disagreement between parties, whether the timelines should be stopped, the rules say that it will go on as per the timelines mentioned in the rules. Now, it has another impact apart from the delay and everything. It is the cost involved. Now the parties are usually, and especially from a in-house counsel's perspective, the most important thing that you would ask us is, why am I going through double the cost? So while the cases, if you, for example, and I'm not comparing institutions here, that's not something that I want to do, but when you file a case with SIAC, and if you want to mediate, SIAC will send your case to SIMC. So the arbitration case will go with SIAC, and the mediation case will go with SIMC, which are two different organizations. However, in our case, once you are filing an arbitration and you want to mediate as well, both arbitration and mediation will go under the same head, which is AAA ICDR. However, the arbitrator and the mediator will be separate. Now the question in your mind would be, I'm still paying double the fee. I'm paying the arbitrator and the mediator as well. And there is an administrative fee as well for the institution to conduct these arbitrations and mediations. So I would like to emphasize that for a mediation, the administrative cost that AAA ICDR charges is $75 per hour. That is negligible when parties come with huge claims. They would not think about $75 per hour. And in our experience and having analyzed the caseload that we have received, what we have understood is that if parties are really serious to mediate, the average time taken would be somewhere between 10 to 15 hours to resolve a mediation case, to come to a settlement. So in that case, if 10 hours is taken, the administrative cost comes to $750, which is absolutely, it's a very reasonable cost to come to a final conclusion of a large claim matter.
Plus you have quality.
Yes, definitely. It is process driven, it is quality, there is trust. And if at all the mediator is not responding, you write to us that the mediator is not responding or the arbitrator is not responding, because sometimes counsels hesitate in reaching out to the arbitrator or mediator because they don't want to jeopardize their stand. They don't want to tick off the arbitrator. So they can reach out to us. It's our responsibility that the arbitrator is functioning in a timely fashion, and we will take care of it on your behalf so that the councils are not bothered with the process. And apart from this, there is definitely mediators cost. I must mention that it is not just $750 that will be required. Mediators also need to be paid. So if your mediation and how it goes is resolved in 10 hours, the mediator's cost will also be not too much. So mediation is something that is picking up now in Asia, even in litigious jurisdiction as well. US is also considered very litigious jurisdiction, but still their mediation is now very progressive. And in fact, to give mediation a further push, all case managers of ICDR were given incentives if they can just get both the parties to mediate. And this actually portrays the ethos of an institution, that they are looking, their aim is to resolve the dispute. Their aim is not money making. It is resolution of the dispute. So that is another trend that is upcoming. Another thing is online case management system. Earlier, all case management was done manually, and courts were also, the filing was done manually thanks to COVID. Not thanks for COVID, but thanks to COVID, that now we have e-filing system in courts. Similarly, with us, not just the filing can be done electronically, the whole entire case management is electronic. So your all the documents that you are uploading in our case management system, they're absolutely secure. Data protection is provided. So all security is provided. So now, although AAA ICDR has been using online case management system for a very long time, but now HKIC got their first online case management system, I believe 1 year back. ICC has said that they are working on it. They're working on it. They will get it out soon. SIAC will roll it out probably next year. So that is another trend that is upcoming. Now, the other part of your question was, what are the challenges that we are facing? As far as challenges are concerned, I would just talk about India. The biggest challenge is that despite there being brilliant institutions, most of the arbitrations are still going to ad hoc. Now, this is the biggest challenge that we have in ad hoc arbitrations, though the perception is that they're cheaper. But since it takes such a long time, eventually it becomes way more expensive than institutional arbitration. So that's one challenge that we are facing, converting ad hoc arbitrations to probably institution arbitrations. And I'm not saying that choose AAA ICDR. I would want that, of course. But I'm saying the shift from ad hoc arbitration to institutional arbitration, whatever institution that may be, is the need of the hour, and we must proceed with that. Thank you very much.
Thank you so much, Asta, for the detailed answer to the questions. I think the key takeaway, from an in-house counsel's perspective here is, one is definitely, the summary of it is privacy, right? Because as opposed to a traditional court system where everything is public, here it's done indoors. So there's absolute privacy. Second, I think in terms of the entire case management itself, like you rightly said, all the necessary, actions in terms of data protection, as well as, all the other aspects like, no tampering and all the protocols, are followed. I think that's the great part. And also, I think in terms of the whole mechanism itself, it's quicker and it's efficient, right? So that's what we want, end of the day. So I think it kind of ticks the boxes. With that, I'll quickly move on to Mr. G.V. Rao, sir. Thanks for coming over. I think you don't need any introduction, so I'll quickly, move on with your first question. So being a senior litigator, you spent like, I think, a lot of time on the field, right? So can you touch upon how ADR has actually evolved in India, and in what way has it impacted senior litigators like you? I think the audience will definitely love this question.
Thank you. Thank you very much. Well, it's a right question for somebody like me who's been there for more than 3.5 decades in the legal arena, and most of my work I started in the Supreme Court, at the then Attorney General's chamber, famous now, who argued the Ayodhya matter, Mr. K. Parasaram. And we've seen, the legal system and, the adversarial system transform, and the alternates come forward. And therefore, the Arbitration Act, it took a turn sometime in the 80s when, the Arbitration, Mediation and the Conciliation Act came into force. And gradually, for all commercial disputes, it was the go-to forum and the method. Earlier, arbitration used to take place by court appointing XYZ retired, by and large, retired judges who, depending upon the kind of matter, the kind of, stakes involved, or whether there would be a senior or a Supreme Court advocate, retired Supreme Court advocate, or a High Court advocate, depending upon whether it was, some property matter, or if it was a commercial dispute. So it would all be like ad hoc, courts would choose and the court would appoint the arbitrator, and then, it could go on for a long time also. But by and by now, over the years, the alternative dispute resolution system has fallen into place, and it has become more and more sophisticated, more and more nuanced. And also due to the fact that India being a destination for, great foreign investment and great enterprises coming in and businesses. So likewise, the arbitration and mediation, etc., have the alternate dispute resolution mechanisms have increased. And by and large, senior counsels like me or anybody else, what everybody has sort of transformed themselves. Of course, some people just specialize in mediation and arbitration, etc. But some of us, we've sort of, transformed into being able to handle matters even before an arbitration, or try to, bring about a settlement. And you have to do that because most of the time now, the arbitration, mechanism and the ecosystem has grown in such way that we have pre-litigation mediation. Now court sees there's a matter where it could be solved by going to a mediation center. It would say, why don't you just go to the mediation center and see if you can resolve it, and then we will continue if you have failed to do so. And the mediator has to give a report saying that, the mediation has failed. By and large, now mediation has also come. There's an act for mediation. Now, arbitration and mediation are somewhat slightly different. Arbitration is an informal method for resolving the dispute, essentially commercial disputes, by, not having the formal ways of going into court and hearings, etc. You could have a dedicated Center for Arbitration, or you could go to the International Center for Arbitration. And now all of these arbitration centers, one in Mumbai has come up, the Delhi arbitration center is there. There's one in the Gift City, which is getting involved. So commercial arbitration is now evolving by institutional, what is called the institutional arbitration. Their disputes are lengthy. There are, a lot of documentation has to be gone into. Again, those centers also have retired judges by and large as arbitrators, but then there are some experts, lawyers also who act as arbitrators. So institutional arbitration and ad hoc arbitration, they are moving side by side, but for larger, for instance, the Hyderabad center is a world-class center. It's a world-class center like the SIAC and the other arbitration centers that you're talking about, the ICC in Paris or the Stockholm or the US, AAA like she was saying, or the Hong Kong, all of these, the infrastructure is matching. So international commercial arbitration, is more easily dealt with such a advanced and well worked out and well designed system for. It is our premier center in picking up work, and it's getting busier and busier by the day. Recently, the SIAC, which is the #1 arbitration center of the world, has signed an agreement with the Hyderabad International Arbitration Center that we have there. So that those things are evolved, getting developed by and by. And people like us, litigators, also go and appear in these places for arbitration matters. Because at the end of the day, your knowledge of law is important. At the end of the day, you need to find methods by which you want to resolve the disputes for the clients and in a more relaxed atmosphere or by a dedicated forum. In a court hearing, you get a date here and then it goes off to another 3-4 years. These things can go on for days and can be resolved during a particular time. So a lot of lawyers have just gone into becoming arbitration lawyers, exclusively dealing with arbitrations in these forums, and they're able to help. So it's something which we also have adapted ourselves, and we think that it is fruitful and it is very beneficial to the legal system and the people at large looking for remedies.
Thank you so much, sir. So I think next, Mr. BGK, I'd like to check with you, since you've been in the banking domain predominantly, right? So how is ADR, viewed in the banking arena? Because I think banks traditionally used to be reluctant, right? So probably things have changed. So I'd like to hear, your views on the banking sector in particular.
Yeah, I think before I begin, I have one thing is that, Asta was saying about so many cases being settled, so thank God that it is not pertaining to mostly in India, because, it's a global scenario you are saying. Otherwise, me and Mr. Rao will be out of job, because I know. One thing is that, one or two questions, one or two issues we need to understand is that today arbitration is for real. That is not disputed anywhere. And, we have, as Mr. Rao said, that there is a global infrastructure in Hyderabad, in Mumbai, and, in Delhi, and, other places. But how many of us make use of that? We still are addicted to one thing, that we want ad hoc arbitration. Because, when a judge retires from the High Court, his sole aim is that I have to make up the entire money which I have not been able to make up during my judgeship, and therefore that comes only from arbitration. And we advocates are also responsible for that. And we believe that, yes, arbitration is there, I have to name him. And one thing is, Senior Advocate Rao said, is that, Section 11 petitions are still pending. A lot of Section 11 petitions under the arbitration is still there. In Bombay High Court, at least, I appear for a lot of Section 11 petitions. And therefore, in Bombay High Court, in the afternoon, one judge, single judge, sits for that only. And the result is that when I name somebody as an arbitrator, and, definitely the answer comes no. And, then he names somebody when my answer will be no. And ultimately we have to go for a Section 11 petition. That takes some time, because it takes at least, 1 month or 2 months to get somebody approved. And then he names somebody and he gives a time limit. And then one thing is that if it is a senior advocate or a retired judge, he says, the schedule fees is not applicable, and, you can fix it according to your whims and fancies. And after that 12 months period is over, and definitely it will not get over, because depending on the money and the amount involved, and it is extended. But it's only by asking you get extended, because depending on the name of the arbitrator. But Commercial Courts Act says that before filing a suit in the commercial court, mediation is compulsory. But look at the reality of that mediation. That mediation is just a farce. You go there there some advocates will be sitting there. You go there and somebody may not come in the first time, and in the next time is given 1 month's time, and after 3 months, he says mediation failed. 3 months are gone. So either there is no mandatory requirement, mandatory, some kind of a sanction is not there if you don't appear to the mediation, then it becomes. Mediation Act has also been passed now, so Mediation Act is also being passed. So mandatory sanction should be there. And, like we say, commercial courts, you can't file your reply within more than 120 days. That has been reiterated by many high courts now. The latest being Kerala High Court said that, you cannot say that, so that has to be compulsorily there. And if you look at the RERA Act also says that, before the adjudicating authority takes up the matter, he asks you whether you want to go for mediation. Yes, mediation is one compulsory thing which you can go, but mediation may or may not happen, because, people believe that if I mediate and if I write something, if he doesn't approve that, doesn't comply with that, again, I have to come back, and therefore I'll have the stamp of a court or, authority in that. So this is what is the reality. So I'm not saying that, first and foremost is that we have to ensure by an amendment to the act that there should be no ad hoc arbitration in India. Ad hoc arbitration is because whatever arbitration I have done in Singapore is all, institutional arbitration. And, many a times we don't have to go and see them or anything like that. You submit all the papers and, everything, whatever is the necessary fees, and, they prescribe a time limit. And after that, everything is to be given in writing. And after that, the order comes and, we are there. So coming back to the banking industry is concerned, one thing is that why banks are not going into arbitration is concerned. So bank has two things, What happened is I just recall the case of Booz Allen Hamilton versus SBI Housing Finance Limited, where, it's a 2011 case, but, wherein it has been completely written, whereas it has been elaborated, the guidelines are there, what is arbitrable and what is not arbitrable. So one is something, in the case of a bank is concerned, there are many other acts are concerned, the insolvency is there, the Surface Act is there, then the DRT Act is there. So though it doesn't override, arbitration doesn't override those acts or vice versa, or even though there is nothing mentioned in that, in those acts that, if such an act is there, so people go in for the other one because, that is much better. And, it is not something which is easy for the banks. Say arbitration is a private form, thing. You don't have to go to the court and you do it there. Even if it is an arbitrable thing, then what happens is people use insolvency. Insolvency is concerned and arbitration cannot do anything of that sort. So insolvency is now most successful. So even after insolvency is coming and most successful is IBC is coming, now the IBC feels that prior to bringing somebody into the IBC, there should be some kind of a pre-mediation where a restructuring or a outside the IBC, some kind of a settlement has to be there. A consultative paper will come very soon. I think they are asking for the views of it. So banks doesn't go, maybe in retail things banks do go, in the case of a vehicle or in the case of a housing, in the case of some goods or something like that, they may go. But otherwise what happens is that, banks does not go for this thing. The first case was HDFC Bank's case was there with Satyapal Singh. And, Delhi High Court upheld that if there is an arbitration clause, you have to go for arbitration. But that was overruled by the Durga Prasad's case in yeah, Durga Prasad's case, where, it has been said that, what is arbitrable and what is not arbitrable. Everything which is not arbitrable, everything which you find is not arbitrable. So you have to understand that where what is arbitrable and what is not going for arbitration. So unless in the other ways, as far as cross-border arbitration is concerned, the main thrust of India not being a hub of international arbitration. The morning session also, we said that if foreign lawyers come here, India may become a good hub of arbitration. I doubt it, because of the fact is that unless otherwise, courts interference in the award passed by the arbitral awards passed is limited or is completely curtailed to the extent, unless there is very specific reason for the courts to interfere, they don't trust here. They go to Singapore or they go to London or they go to other places, and even in some cases they go to UAE also. So that is where it stands. Banks per se wants is something which they want to create a jurisprudence, because I can arbitrate means, it is restructuring. Arbitration is nothing restructuring. They won't say arbitration is always there in the banking sector in another way by settlement, OTS. OTS is nothing but arbitration, because OTS comes out and, when during the March period, every bank, when the NPA is there, they come out with some kind of a scheme called, this OTS is there. If you pay before 31st of March certain amount, and, if you pay it within 2 or 3 installments, it is there. And even under the SARFAESI Act, ARCs, asset reconstruction companies also come for OTS. So RBI has come out with clear rules that there should be an independent board who will counsel, advisors who will go through it and recommend it to the board, and then the board can accept it. So in all these cases, arbitration in one form or another is always there. It is not arbitration, I would say mediation is always one form or another is there. So the arbitration cannot be taken as the complete source to wipe off all the litigation or all kinds of court cases which we face here. But the fact of the matter is that arbitration first has to be made institutional, and the less interference of the court has to be there. And if there is an institutional arbitration, 90% of the Section 11 petition will disappear, because it is an arbitration has to go to an institution only. So this is where it stands.
Thank you so much for the very practical insights on the ADR aspects in the banking arena. I mean, that was like really helpful. So I think I will turn the next question back to you. Sorry, I think Asta has to leave because she has another engagement. So quickly, Asta will wrap up and you can leave immediately once you've answered this question. So in the, again, interest of the audience, right, this is a very different question for you. So coming from an institution, institutions like you have your own education system, right, which is kind of evolved over a period of time. So how do you think this education system in particular could potentially impact the cross-border, ADR in the coming future? Because, I mean, they are very structured, and a lot of people are actually taking up these courses to enhance their skills and, kind of upgrade themselves, right? So from a practical point of view, again, I'd like you to quickly touch upon the impact, and also where do you think this is going?
Thank you very much, Smita, and my sincere apologies. But I think the most important question has been posed to me, which is the education. And we can talk about ad hoc arbitration and institutional arbitration and the conversion of ad hoc arbitrations into institutional arbitration, but that will not happen. And that I understand that you've mentioned that it must happen, and the legislature should make it so that all arbitrations should now be institutional arbitrations. As much as I would like that, I don't think that can be done.
It's a utopian thinking. I think, I'm just thinking, otherwise what happens is, it will never end. Otherwise it will never end, because these judges can be a part of the institutional arbitration, so they are bound by this thing. And, they have a standard fees, and, therefore, that will end the entire woes of arbitration, and people will take more into arbitration. Today what happens is, I suggest Dr. Rao's name, and somebody will say, no, I want another lawyer, and then both of us will go, and ultimately we'll get a third lawyer who may not be in the liking of both of us, and then we are left at the mercy of these two people. And then second thing is that our commercial codes acts as a mediation compulsory, and that mediation is not a mandate. It is mandatory, but if I don't appear there for 5 times also, there is no sanction or penalty imposed on me for not appearing. And next thing is that it'll go as a suit. So that also has to change. Why for you're suggesting something? It is like even if I don't appear for the KG class also, then I'll get promoted to one, and then I'll go to one first. I'll not. Why should I waste my time in going and studying in KG class, and I'll straight go to the first standard. That is where it stands. And third is that definitely Dr. Rao will agree with me, is that under some pretext or another, and the courts will interfere in any award given, either public policy or that there was a fraud in it, there is some kind of anything and everything. It depends on the eloquence and on the brilliance of the and the face value of the senior lawyer appearing before the court, and it get a stay, and then the entire thing is gone. And that is where it stands. And banking industry is concerned, we go for the IBC and SURFACI Act, because of the fact that it gives a quick reliefs, and restructuring is there. That is what I said. Mediation is there, OTS is there, and OTS is restructuring, and OTS is nothing but a kind of mediation where I restructure it. But even after restructuring, it doesn't come, and then it happens to that.
I completely agree with you that institutional arbitration is need of the hour, and it will benefit only me if that is happening. However, arbitration is a process which the genesis of it is party autonomy. The courts cannot steal that away from the parties and tell them to go to an institution, because that goes against the ethos of arbitration. So, but I do understand the concern that is raised that when two parties are not agreeing on an arbitrator, it further lengthens the process, which is not the concept of arbitration. Arbitration, when it started, it had to be a speedy mechanism to resolve your disputes. Now, what has been done in Singapore to cater to that issue where two parties are not agreeing to an arbitrator, and let's say the arbitration is ad hoc, is that in the International Arbitration Act of Singapore, it is mentioned if two parties cannot agree on the arbitrator, then they have to go to SIAC, who will be the appointing authority. So they will not administer the dispute. They will not be the institution before which the dispute will go on, but they will only appoint the arbitrator for the parties. So this is another way we can look at for a speedy appointment process.
One thing is, I take that point from you. So what happens is, if not a complete ban, then you can fix some pecuniary limit. Pecuniary limit. After that, it should have been an institutional arbitration. The other should not be an institutional arbitration.
Sorry, I think the question to you was on the
Yes.
education. So
Yes, moving to the education bit. Now, the point I was trying to make, as long as we do not impart education, which is the most important, and that is the only way how we can convert ad hoc arbitrations to institutional arbitrations. For this, there are various organizations that are pushing education. One is CIR, Chartered Institute of Arbitrators, where arbitrators can get accredited. And once they have accreditation of CIR, institutions like us, of course, that's not the sole thing that we see in an arbitrator. Okay, the XYZ person is accredited by CIR, we can appoint him as an arbitrator. No, but it definitely helps us, because CIR is a internationally recognized organization which provides accreditation to arbitrators. So we will see that this person has an arbitrator's training. So this is another institution that we can go to and learn about arbitration. And they have several levels. They have fellowship, which is probably the highest level, which is if you are accredited as a fellow, you can write FCIR. And then there is member, which is probably the lowest level of accreditation. And juniors can go and take these trainings and be experienced in arbitration. However, I must point out it is not the case that if you go as a junior lawyer without any experience of having written an international arbitration award, accreditation will not help you. You need to have the experience. Institutions are very careful when appointing an arbitrator. So this is one institution. Second, the responsibility comes on us, the institutions. What are we doing? We are doing arbitrations day in and day out. What are we doing to impart the knowledge? So we have partnered with various law schools like NLU Delhi, Columbia Law School, Stockholm University has a partnership with Stockholm Chambers of Commerce. They run a very successful program, International Commercial Arbitration Law. It is only emphasized on commercial arbitration and how international processes function. I was very fortunate to take up that course, and there they teach you all the nuances on intricacies of international arbitration process. So that is something that we should be doing. And of course, there is a cost involved in all these things, but I can say, because I've gone through it, the cost involved with Stockholm University is very low. It's nothing compared to the US universities. It's a fraction of it. Even 1/10 will be an exaggeration. It's less than 1/10 of it, probably 1/15 of it. So that's what we can look at, how to gain knowledge, how to impart knowledge. We do several training sessions. In fact, once we impanel an arbitrator on our panel, it's not the case that they will automatically start getting appointments as an arbitrator. That will not happen. What will happen is they have to go through a mandatory full-day training with AAA ICDR, and then only their status as an arbitrator with ICDR will be activated. Once they have completed the training, only then they can be appointed as an arbitrator. So this is very necessary for us also to rely on them and to understand that, yes, now this person is capable of handling the disputes and writing down an award, because we are also very cautious about the awards that are published. If they are not enforceable or if they are challenged, it's us who is responsible for it in the end. So yes, these are certain things that we are doing to impart knowledge. There are several conferences. As we speak, there is this conference going on, Delhi Arbitration Weekend, which is being hosted by the Supreme Court of India, the Delhi High Court, and the Delhi International Arbitration Center. It's a week-long conference where several students, young practitioners, senior practitioners, and judges, retired judges, currently sitting judges are also participating, and all they are talking about how we can make arbitration better. So this is another way to impart knowledge, and I think this is now happening more and more, although it becomes very difficult for me because being having the region of entire Asia, I have to attend Hong Kong Arbitration Week, the Singapore Arbitration Week, but I think this is need of the hour and we need to impart more knowledge.
Absolutely. I think I can't agree more with you. So I think, the gist of it, what I understand is education definitely plays a vital role because, it enhances the quality of arbitration, of course. And also on the other hand, institutions like yours and the arbitrators are both kind of interdependent, right? I mean, if one is not good, the other also is obviously impacted. So I think to strike the fine balance is what we're trying to do. And generally, I think we will get there eventually. So with that, thank you so much, Asta, for your time here. And I think it was really very nice to have you around, and certain key, I think, takeaways, which probably the audience also would agree with me. It was, the way you put across things, challenges, as well as the importance of education, I think it was lovely. Thank you so much for your time.
Thank you very much, Smita, for asking very topical questions.
Pleasure.
And thank you, Mr. Rao, and thank you, Mr. Balakrishnan. It was a pleasure to be on the same panel. And thank you for the lovely audience who was patient enough to go through my lengthy answers. Thank you very much. I'll take your leave now.
Sure. So, Mr. G.V. Rao, so I think I'd like to turn the next question over to you, sir. From what you have seen, do you think the ADR concept in India is like really mature? I mean, really up there, like its counterparts in the Commonwealth? If not, how do you think the Indian judiciary needs to gear up towards scaling up itself in terms of the ADR world? So that's the question to you, sir.
I'm associated with the Commonwealth. Recently I was attending the Commonwealth conference of lawyers in Goa. And also I was associated with the Commonwealth University, which is in London and in Benin. We are much better than about 70 or more percentage of the Commonwealth, which comprises of the Caribbean and some of the African countries and other places. So we are among the top in terms of that. I wouldn't like to have a somewhat dismal picture of what my good friend Balakrishnan has, but I would say that I refuse to look at things which are, in a way where you feel that they're not good enough, or of course, everything there's room for improvement for everything. But I wouldn't look at it as if it is the end of the road and then nothing can happen to it. That's absolutely wrong. Yes, we as an ecosystem of legal fraternity, we need to pull up our socks. Right across the country, in every field, things are moving ahead. We are a great destination for foreign investment. Industry is moving ahead. Politically, we are seen as a country where great growth rate is there, and we are growing at about 6 to 7%, somewhere around that, which is one of the best in the world, and things like that. But yes, we have an archaic mindset. Our alternative dispute resolution mechanism is not as modern as it ought to be, is not as fast as it ought to be, is not as as effective and giving the necessary remedies. But we are getting there. It's not as if we are not getting there. I would say 3 years down the line, maybe in another 5 years down the line, especially, you see, I've done matters where clients from overseas really, I did many, about almost 2 decades ago, there was this company from Hong Kong which was investing in India call centers, and they were thinking that they should have the Hong Kong Center for Dispute Resolution. But, my Indian counterpart, my client, he said, look, it's so expensive for me to go there. I mean, why would I do that? No, the Indian court system is not so good. So we sort of came to an arrangement where we said, all right, we will do arbitration or, mediation or whatever possible to resolve the dispute amicably instead of going through the court system. And then they agreed to it. The Hong Kong investors agreed to it. So therefore, it's not as if, we are totally incapable of providing an effective alternative dispute resolution mechanism at all. That's absolutely not the way to look at it. That's not the way to think about it. Yes, we do have difficulties. When I find my friend criticizing the system, he says that, we need to improve. But it doesn't mean that there is no scope for improvement and that it will not improve. That is something that I wouldn't take it. And I see that the courts, I recently wrote an article about certain interference in a Singapore arbitration by an Indian court. And I was critical of the fact that they actually interfered in it. Because the whole purpose of going to institutional arbitration and to arbitration is that the court would not come back and interfere. Now, today, Mediation Act latest, what it says is, if you enter into a mediation and it is settled, then it will be enforced unless it's been obtained by fraud or deception or any other kind of, extra legal methods. And that's it. So even a mediation is now becoming enforceable under the latest act. Therefore, the courts are very, very proactive to ensure that arbitration remains arbitration, and it has less to do with the court interfering with it in a day-to-day manner. Otherwise, it is endless. There will be nothing. I mean, they are refraining from interfering in arbitration. They've restrained the temptation to go and interfere in it, the courts themselves. And they've understood the fact that the system cannot function if you were to go and interfere. On the contrary, they encourage mediation. They welcome arbitration. They refuse to interfere in arbitration. That is the trend. Now, exceptions don't make the rule. There are always exceptions. So we always tend to look at some exception and say, oh, court has interfered in some celebrity, in some case, like the Singapore case, which prompted me, as one of those legal journalists to ask me to write an article. And there also I said it isn't correct on the part of the court to interfere in that matter, in one very well-known family matter. So therefore, the thing is, I find that the court is becoming proactive. It is being, it is invited. One of the young ladies told us about the conference that is being held or going to be held soon, where all of these people participate. The court, it's an enlightening process where the court itself finds not wanting to interfere or in an arbitration procedure and give it a stamp of approval, where it is fairly, the award is fairly. I myself was an arbitrator in one matter, which was the Delhi High Court referred to me, and I told the parties, you have one last chance to resolve this dispute in the next 10 years. If you listen to me, I'll do it. And the way to go about it is there should be a third method of alternative dispute, which is a combination of arbitration and mediation rolled into one, where you do give it some kind of formal character in terms of hearing, but the arbitrator is a little more proactive in ensuring that there is a mediated settlement. We will evolve. We can evolve. The fact of the matter is the courts have been burdened. There is a huge burden for results and remedies to be given, to relief to get. And at the same time, arbitration is also evolving and mediation is also evolving. And the courts are conscious of the fact. It's not as if that, at the drop of a hat, they're willing to go and interfere in a arbitration proceedings and, they are more and more conscious of the fact. So there is a general overall improvement. If you say, how much is the percentage of improvement? I would say 15 to 20%, 30%, good enough. I mean, where will you get an overnight 100% improvement in a system? But you cannot fail to make an effort. You cannot fail to look at it positively. You should make every effort that you can humanly possibly make to get the situation better. And to arrive at that, the same choices that you would have in choosing a doctor or a chartered accountant or any other activity or choosing a restaurant you want to go, you would like to do it to the best available. And you would like to find the methods of doing that, of advising somebody, and you will have to find people who are committed, who want to see, ensure. I mean, what a legal professional, by its very nature, must be the one who is the happiest when he finds his clients has found some relief, is finding a solution, is there to advance their cause. The system is functioning. There are people who are making tireless efforts towards it, and go ahead and do it. If we don't that way, we wouldn't be where we are. I mean, it's not that, India is in the boondocks. No, sir, it is not. It is making, if it can be done in every other sphere, whether it be science, technology, electric vehicles, anything, name it. Why not in the legal arena? I'm sure it can be done. It's not as a hopeless situation. Some of the best and brilliant minds are in the legal fraternity, And it's only a question of commitment. It's a question of being, desiring to get there. It's a question of getting other people to do the same. And that's when we find results. And that is a thinking that is coming about among some of the leading professionals. And they want to do it and they want to encourage others to do it. Because it's better to light a candle than to curse the darkness. It is better to prevent than to cure. You must similarly, I was at a conference just now on trade secrets and espionage. And I told them that all the legal professionals should advise their clientele first how to protect their proprietary rights, how to protect their intellectual property. And thereafter, if it fails, if you're taking enough protective measures, preventive, then you go ahead and use the legal processes and use it well. Apply yourself. Be encouraged to think the right, be encouraged to find the right people, be encouraged to, these sessions are for this kind of thing, where everybody tries to see how we can find solutions to things that I, as a lawyer, was trained in a lawyer's office who never worried and spoke about a problem. He would only tell me, give me a solution. Don't tell me what's the problem. I'm not interested. Tell me, how do we solve this? Tell me, how do we get better to this? And that's the mindset that we should need, at least if the legal ecosystem is not functioning, is not as healthy as it ought to be. Thank you.
Thank you so much, sir. So I think,
I think, I need to.
Quickly, because I think
quickly, it's 5 o'clock.
Click the balloon.
What happens is, I think there is no perfect fit or perfect man, human being in this planet. Even Parampurush, Lord Rama was also, having some kind of accused of, leaving his wife, because of the hearing. Somebody told that she lived with Ravan. So my suggestions were that, the solutions to how to improve the existing system. My suggestions were that, I never said that, the arbitration or the ADR mechanism or the mediation in India is failing. My suggestion was only to how to improve it, So it's like, how a child is growing up, you give some more vitamin or, you give some more kind of, food. If somebody is bodybuilding and somebody takes some kind of medicines to build up the muscles, and the muscles is needed, that is what I told. Because of the fact that, it's practically, we have seen in some cases, it's absolutely the Indian legal system, and the younger the judges are coming now. And, I can name many of the judges who are very wonderful judges in the sense, they are not the old school of judges who are well read, and who are aware of the artificial intelligence and, what is happening, who can vibe with younger generation. And, they are all very good judges are there, in the Indian system. I can't name them, because personally many of them are known to me, so I can name them, that how good they are, and when we go there, we know what is happening. So today what happens is, I'm only saying is that, this system has to be improved, and the improvements only I have told is that the improvements which has to be there, there may be always some bad apple in the entire basket, and that bad apple cannot be equated and said the entire basket of apples are bad, that I agree. Because India has made tremendous progress, as far as India is concerned, the legal system is concerned. I'm not on the other things, that is not for anybody to say, because for the last few years, it was very there. Overnight, we changed into the system of hearing cases through online or, through VC. That I never imagined in my life, that I'll be carrying a laptop and sitting somewhere and arguing the cases. And even today, now, except for the High Court, I prefer to sit in the comforts of my office and, attend the hearings wherever it is possible. So this is a tremendous thing, it's overnight, nobody, and many people said that, it's not correct, even in the official courts also now that is possible. So improvements is something which is needed, and every day you have to improve yourself, introspect and improve yourself, and then we will reach a goal. IBC came into existence. Now, how fundamental, and when you go there and, when you say file a petition, it is settled. I don't want the company to be given to a IRP or an insolvency professional who come and take away entire thing. So improvement, saying that you can further improve. It's like a school teacher saying that you have the potential and therefore you have to improve. That should not be taken that the teacher doesn't like me. That is it.
Thank you so much. So I think we have overshot the time, but it was a lovely panel indeed. And I think the wealth of experience each of them brought to the table was amazing. So thank you for being a wonderful audience. I'm not too sure if we have time for Q&A, but we can take it offline. So thank you.
Thank you so much for such a great presentation. It was a perfect showstopper of the day. Let's have a huge round of applause for all our panelists and keynote speakers here. Also, I would like to take this opportunity to thank Honorable Dr. G.V. Rao for his support throughout, and our association partner, the Indian Society of International Law. Thank you, sir, for your support throughout the conference. Let's have a huge round of applause, everyone. With this, we come to the end of day 1 of the LexTalk World Conference. I hope you enjoyed your first day here and that you're taking a lot of knowledge and strong networks. We will see you tomorrow at the same place. Till then, enjoy the evening and keep growing. Thank you, everyone.